All right, P5P646574. This is Attorney Schwessinger, Lisa.
Judge, good morning. Robert Novak appearing on behalf of Ms. Du Bois. I'm standing in for Mr. Schlesinger.
Okay, I just need you to start your video if you would, okay?
Of course, Judge. I'm sorry.
It's all right.
Am I on?
No, I still don't see it.
Here.
All right,
you go.
there you're gonna go.
There we go, Judge.
All right. I have a stip form here that says that you are going to plead responsible on behalf of Ms. Du Bois to the charge of impeding traffic with the speeding to be dismissed. Is that right?
That is correct, Judge.
All right, and you're authorized to enter that plea on her behalf?
I am.
All right, to the charge impeding traffic, responsible or not responsible?
Responsible.
Plea is accepted to impeding, the speed's dismissed, 150. I'll give her until October 30, okay? Thank you.
Judge, what do you mean October 3rd?
30th.
Oh, October 30th. My apologies.
Yeah, that's all right, to pay, no problem.
How much was the ticket? I'm sorry.
150.
She'll take care of it by next week. Thank you, Judge.
Have a good day, thanks.
You too, bud. Bye-bye.
Nicole Renee Merriman, 25T646424. Mr. Young's on this one.
He's not on Zoom. He must be in person.
Is Mr. Young's out there?
I saw him in the hallway. He was out there. Mr. Youngs was here. He said he was going back to his office.
Joshua Michael Zarati, 25F243398. Come on up here, sir. Your name?
Joshua Michael Zarati.
I placed you on probation on May the 15th of 25. You had pled to operating while impaired. I now have a probation violation here that alleges you violated probation. The probation department thinks that you failed to refrain from consuming alcohol or drugs, testing positive for alcohol on September 29 and 25. That will be a first technical violation. If you plead guilty or if you're found guilty, you could get 5 days in jail. Do you understand that?
Yes, sir.
Did you sign this advice of rights, revocation of probation?
I did.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing. Do you understand that?
Yes, sir.
You have the right to an attorney. I'll be happy to provide you with one at public expense. Would you like a lawyer?
I would, Your Honor.
I'm sorry?
I would, Your Honor.
Okay, I'm going to go ahead and enter a not guilty plea. We're going to go ahead and set you up with a lawyer. I'm entering a not guilty plea.
Is this a court-appointed attorney, Your Honor?
Yes, sir.
Okay.
Okay?
I'm sorry, can you just repeat the non guilty?
I'm entering a not guilty plea. We're going to set you up with a lawyer.
Okay.
Go talk to the lawyer. After you talk to the lawyer and you will come in here and we'll handle this.
Okay, Your Honor.
Is that all right?
Yes.
Did you want to go hire your own?
No, I did not. I just wanted clarification.
Okay, no problem. All right, go out in the hallway. He'll set you up with an attorney.
Okay,
Thank
thank
you.
you.
Dick Hayes, Nathaniel David Hayes, 25T643636. Could I also have Ronald Derby having a seat at the table there? Up here, my right, your left. Mr. Hayes, come on up to the podium, state your name.
Nathaniel.
You have a charge of transportation of a firearm. You have the right to an attorney on this. Would you like an attorney?
I've never been in trouble.
That's okay. I don't need to talk about that. I just want to know if you want a lawyer.
Would it be advisable?
We'll give you a lawyer. You go out in the hallway, you talk to the lawyer, and
I just don't want to look at my gun.
hang on. I don't want to talk about this, okay? So you go out in the hallway, he'll set you up with a lawyer. and then you'll come back in front of me, okay? Donald Henry Derby, 25G811, come up to the podium, 75A and B and C. And could I have Bennett seated at the table here? Your name, sir?
My name is Donald Henry DeBry.
Good morning.
Morning.
Is it Dubry or Derby?
DeBry.
How do you spell that?
D-U-B-R-Y. I think it's spelled wrong.
They spelled it wrong on the citation.
Yes.
Lisa, I'm going to go ahead and change that on the file. It's spelled D-U-B-R-Y. Sir, you have a property code violation. You have three of them, actually. Storage of unsafe equipment, no protective treatment on home, bare wood, promoting rodent habitat. You says you have piles of junk, 3 misdemeanors. You have the right to a lawyer. Says you've refused to respond to any letters or personal visits. So you have the right to an attorney. If you want a lawyer, I'll give you one. Would you like one?
No,
You sure?
I don't need one.
Okay.
I was in the hospital.
Hang on.
I'm sorry.
I'm going to go ahead and arraign you. I'm going to send you to the prosecutor, okay? They think you own the property at 31021 Adams Drive in Gibraltar. And they think that on September 30th, 25 at 10 a.m., that you had 3 different property maintenance violations. You stored equipment, storage of unsafe equipment, no protective treatment on home, that there was bare wood, and you promoted rodent habitation, piles of junk. These are all misdemeanors. And I'm just reading off the citation. They are punishable by up to 500 fines, 90 days jail costs, or all of those. Do you understand that, sir?
Yes, Your Honor.
All right. Did you sign this advice of rights?
I did.
Did you read it?
No.
You didn't read it? What if
I
you,
see the yellow form.
no, this one right here, the advice of rights, please, this one here, the white form. Don't ever sign something you haven't read. What if you signed your house over to your neighbor? You know what I mean?
No,
I'll
I
cover
just like these 2 yellow things.
He's confused on the copies.
This has got your signature on it, sir.
Well, then I see.
Come on. Well, let me cover the rights with you. You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right at a trial to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses, to testify or remain silent. If you remain silent, that silence would not be held against you. If you plead guilty, you're giving up all those rights. You're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt, and there would be no trial of any kind. You understand that?
Yes, sir.
All right. Do you still wish to waive your right to a lawyer?
Yes.
I'm going to enter a not guilty plea for you. I'm going to send you to the prosecutor. You can talk this over with the prosecutor. Okay?
Okay.
And then either way, you're coming back in front of me here. You understand that, right?
Yes, sir.
Okay. We'll see you back here in a few minutes. Good luck.
Yes, sir.
Kathleen Boudry. Would I pass you, sir? What's your name? Oh, okay. This one got snuck up here. I'll take you next. Kathleen Sue Boudry. Come on up here, ma'am. 25G306 660. How you doing today?
Good.
Your name?
Kathleen,
How many times you been in court?
excuse me,
How many times have you been in court?
never.
I didn't think so. You got a perfect record.
Do I have one?
You have a perfect record.
Yes,
You've been law abiding.
yes,
You're not nervous, are you? No.
no, I'm not there.
All right. So you're gonna plead.
Not, no, too much.
You're gonna plead to impeding traffic, right?
Yeah,
You met with the department rep. He offered you that, and that's what you're going to do.
yeah,
That's 0 points. It won't go on your record. Do you understand that?
yeah.
To the charge of impeding traffic, you plead responsible or not responsible.
I'm responsible for impeding.
I'll accept the plea. Speed's dismissed. $150 and you're all set. Okay?
Thank you, Judge.
I'll tell you what, you've been so law abiding. I'm going to cut your fines way down here. Okay? You made it to 42 without having a ticket. age 42. 100.
42, I'm 79.
Oh, no, I thought you were 40. You look like you were 42 to me. 135. You're all set. Have a great day.
Have a good.
You too. Dakota James Bennett, 24W834-8538. Mr. Bennett, your name? I placed you on probation. Actually, I did not place you on probation. This was an operating while impaired. I simply fined you and ordered you to complete community service. $16 hours by March 1. And I have a charge here that alleges you failed to complete 16 hours of community service by March 1. If you plead guilty or if you're found guilty, since you absconded,
Hey, I'm not too sure what's really going on with it, because I paid all my fines.
stop. Just let me explain, okay? You were supposed to come in here for a show cause on this charge. Failure to provide proof of completing your 16 hours community service by March 1. We set it up for May 22. You didn't bother showing up. A bench warrant was issued. You came in and paid in full. But you had an outstanding show cause violation. So if you plead guilty here, if you're found guilty, I want you to understand that since you absconded, actually, I'll count you not having absconded since you came in here on June 10th. I'll take that as being our fault that occurred, but I don't think it was. Because I'm going to read it to you. Defendant paid in full, June 10th. Cashier canceled warrant by filed case on probation shelf, not realizing defendant had an outstanding show cause. Defendant video rain on new Judge Hesson case, set this case on same day as new pretrial with Judge Hesson. So I'll just tell you, you could get 5 days here. You understand that? And did you sign a yellow advice of rights revocation of probation? Did you?
Yes, sir.
If you plead guilty, you will be giving up all those rights and there will not be a hearing or a trial of any kind. You understand that?
Yes, sir.
All right. You have the right to a lawyer. If you want a lawyer, I'll give you a lawyer.
Thank
I'll enter a not guilty plea for you.
you.
Indicate you stand mute, set it for a revocation hearing. You can go out in the hallway. We will set you up with an attorney. You'll come back in front of me today. Do you understand that?
Yes.
Do you have any questions?
Not bad indeed.
Okay, you can go right out in the hallway. Good luck. Height, Jeffrey Richard Height, 25G306678. Mr. Height, your name?
Jeffrey Height?
You know, it's just, you weren't really operating while texting, were you?
No, I was looking at my map.
I see people texting all the time. They must not pay attention. I don't get it. Why are people doing that? But anyway, you're going to plead to impeding?
Yes.
Don't do this again, okay?
I've never been here before.
To the charge of impeding, responsible or not responsible?
Response.
I'll accept the plea. 180 is your total. Cashier into the hall to your right.
180.
180. If operating while texting is a $215 ticket.
Okay. They said 150.
Well, they're not the judge.
Thank you.
People against Garrett Forgash, 25T64532228.
Great for the defendants, before I step
Good
forward.
morning, and I also have a B file here, Mr. Zelnick.
Yeah, still in fraction, your honor.
Yes.
I'm up here on that one too.
Okay, sir, your name?
Garrett, okay.
Okay, so this is first of all, does he stand mute and waive formal reading?
Really does, your honor.
And now there's going to be a plea to operating while impaired with the PBT refusal and super drunk to be dismissed, true?
Yes, Your Honor, will stipulate also for the plea for the blood alcohol test on the data master of 0.18.
Sir, is that what you want to do, is plead guilty to operating while impaired? If you do that, the possible penalties are up to $300 fines, 93 days jail, 360 hours community service. Court costs of all of those 4 points would be added to your record. Your license will be suspended or revoked in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record. Do you understand that? And did you sign an advice of rights form here today? He has to sign this.
Oh, you did, Judge.
Oh, you got
One in
one?
the file, yeah, they made him sign it before.
Okay. Did you sign it and read it and understand it? If you plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that? You nervous?
I'm.
Good.
That's the first time I've heard that one, Judge.
To the charge of operating while impaired, how do you plead? Were you operating a motor vehicle on Lafayette near West and Trenton, September 5 of 25 at 12:30 in the morning? Did you drink alcohol prior to that? And if so, what did you drink and how much? Nice and loud for me. I got to hear you.
6 beers.
Okay.
They were IPAs, Judge, so that's about 9 or 10.
Okay. And was your ability to operate the motor vehicle impaired due to the consumption of the alcohol?
Yes.
In what way? Why were you pulled over by the police? You think you were speeding at least in part because of your alcohol consumption? And Mr. Zelnick, was this a intoxilizer? No, it was a blood draw, correct?
Yeah, I thought they drew blood. I request. Oh, they gave an option, Judge.
Okay.
That was pretty good. I've never seen this before. There's no refusal.
Okay.
It's like a buffet when you go to the Trenton Police Department.
Okay, so you stipulate that the blood draw of 0.18 was accurate, Mr. Zelnick?
It's incontrovertible, so we stick.
Are you on probation or parole right now, sir? Anybody in the world force you to plead guilty?
No.
Plea is accepted to operating while impaired. The OWI, or I'm sorry, the super drunk charge is dismissed. Refused PBT is dismissed. I'm going to refer you for a screening and assessment. We'll give you a sentence date here momentarily, Mr. Zelnick. Sir,
You have a court school coming, Judge, or not?
gosh, I do want April 30, but
My.
I mean on October 30.
It's pretty full, Judge.
Lisa, we got 3 or 4 there. We got 3 for that, don't we? I think we have 3 already.
Yeah, we have 3.
There's a cancellation, we'll be glad to help out. I think
Okay.
it's an ideal example is work, his community service that he's done in the past, the family's history in town would be a good appearance. But if not, we'll come here and be good.
Okay, no alcohol, no marijuana, no illegal drugs. You cannot purchase, possess, or consume any one of those. You cannot leave the state, cannot violate a law. You must appear in court as directed. I do want you going to AA, NA at least 1 time a week, okay? We're going to hand you a form. I want you to go in person. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you. Do you understand that? I'm sorry. Okay,
He's truly a soft spoken.
I can tell. When's the sentence date, Lisa?
November 6th at 8:30.
Is that good with you?
We'll make it work. I think that's a Thursday, Judge. Is that, am I,
Yeah, that's a Thursday.
we'll do that. If there's a problem, notify the court.
Okay.
It's always accommodating, and I think, like, blind and progressing properly is important today.
Good. What does he do for a living?
I work for waiting rooms, schools,
What do you do for them?
building services.
Good. All right. We'll see you back here on November 6th. You can go down the hall, get your notice, and then go over to probation where you'll fill out a questionnaire and be interviewed. Okay?
You're right.
Thanks a lot, Mr. Zelnick. Nice to see you as always. Nicole Renee Merriman, 25T646424. Mr. Young, your name?
All Youngs.
You're going to plead to impeding on her behalf, right?
Yes.
You're authorized to enter into that plea, true?
Spoke to her this morning. Yep.
To that charge, impeding traffic, responsible or not responsible?
Responsible.
I'll accept the plea, dismiss the speed, 150. She has until October 30 to pay, okay? Have a great day. Thank you.
150, 150?
150 by next Thursday, okay?
Got it. Okay.
Thanks.
Thank you, Judge.
You too. Sean Mary Reed, 25G81171A. And she's compliant.
Good morning, Judge.
That's good to see. Somebody's picked up their property when they need to, right? Your name, ma'am?
Sean Mary Reed, Your Honor.
They're moving to dismiss. They say she's compliant. Case dismissed. You're all set. Have a good day.
Your Honor.
Jacob Kelly McSuch, 23T640501.
Good morning, Judge. I'm here to turn that one to Masuch, who's in the stage.
Mr. Masuch, come on up to the podium, please. Tell me your name.
Jacob Mack.
It's Massage, okay. All right, so sir, he pled guilty to assault or assault and battery. Actually, he pled no contest.
Correct.
I want to know right now if there is an Adam Forstall here, either on Zoom or in person. Is Adam Forstall here?
Not on Zoom.
Uh, I need to know before we go on, what is going on with the relationship here? This was,
Mr. Message, I apologize. Mr. Message was in a relationship with Mr. Forstall's stepmother.
right.
And the argument ensued while the parties were living all the same residence, Judge. All came down to an issue with the animals, and they were actually defecating and urinating in the children's playpen. So they were moved to the upstairs bathroom for the night. The next day, the mother came out, was upset that the cats, the dog was put into that bathroom. An argument ensued between her and her daughter. Mr. Masach came upstairs and kind of tried to straighten things out. Things kind of got out of hand, and Mr. Forstall got involved, and there was an altercation between them.
Okay. What else? I saw that happened. I just wondered, I read the report, but I
They're
just,
no longer living in the same residence. And he's no longer with the Miss Rellinger.
okay, good enough. Everything else in the report is accurate.
Everything else in the act, we've had a chance to review, Judge. We had no corrections and deletions. Judge, I would say that Mr. Message is 26 years old, Judge. He's a single father. He does have 3 minor children. He is full-time employed, Judge, with All American Enterprises. Where he does construction and handyman work. He's been had steady employment for at least the last year. He doesn't have any criminal history, Judge, other than this pending case and a moving valuation back in 2023. So Judge, he doesn't get in trouble. Overall, at this point, all he cares about is just going to work and he takes care of his kids. And he understands that maybe there was tempers got out of hand that day and things could have been handled better, and now he just wants to do whatever the court sentenced him to, Judge, and to put this behind him. And I believe he'd like to address the floor before.
Fair enough. Sir, what would you like to tell me?
I want to apologize for my actions. I could have handled the situation a lot better than I did. And I want to get the whole situation behind me and move forward from.
10 months probation per the agreement. I just saw that it's taken under HIDA. You cannot leave the state without the consent of the court or violate a law. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. You're to obtain and maintain employment and provide proof of that. You do have to obtain a high school diploma or a GED. You need to do that for you, not me. No contact with Adam Forstall. You're going to write, phone, see, text, email him, or have anybody else do any of those things for you on your behalf. You're not to possess firearms. You're not to possess dangerous weapons. None of those. Do you understand that?
Yes, sir.
You're to clear all your warrants by November 7th. They're recommending 30 days. I'm going to give you 2 weeks to go clear all those warrants. Do you understand that?
Yes, sir.
Anger management with 8-week follow-up, no contact with the victim, no firearms, no dangerous weapons. 3 days on the court work program. There's a $35 a day charge for that for a total of $105. You're going to pay fines in the amount of $100, costs $175, $75 victim's rights fee, $50 justice assessment. So your fines and costs are $400. Probation fees are $200 for $600. Screening fee is added in. And the court work program fees, everything included, is $765. You pay that, you stay out of trouble. We'll give you a review hearing date. You'll come back here. At that time, we're going to give you one for sometime in 2026. It'll probably be early August. We'll give you that date. You're going to go down the hall, get that date in paper on your paper notice. Then you go meet with probation. We'll explain the order. Do you have a review hearing date, Lisa?
August 13th of 26 at 9 o'clock.
August 13th of 26 at 9 o'clock. Can you pay all these fines today?
Judge, there's a $300 bond that was posted on this case.
Okay, that was, let's see, I believe that's a 10%, yes. So he has 270 to apply. I just want to make sure it's in his name. It is. So he has 270 to apply. How much more do you have with you?
You have anything?
I don't have nothing with the very bid tomorrow.
How much, do you get paid weekly or bi-weekly?
Judge, if I may, what is the remaining balance?
275 from 765. So what's that? 465, 490.
30 payment bonus,
How much can you pay per week?
30, 40, 50 bucks, whatever you're okay with.
$40 a week, and I'll start you on October the 27th. If you ever don't have the money and you're going to pay 275 now, that's simply, or wait a minute, 270 now. 270 now, so the balance will be more than that. It will be, let's see, 395. Right?
495.
495. Okay?
Judge,
If you ever don't have the money on any of these due dates, no problem. Don't worry about it. Call the court. We'll go on or before the due date, 8:30. I'll be glad to give you an extension, okay? Just don't ignore me.
Judge, would the court consider early termination if Mr. Message was to?
I will always consider early termination. It's a question of whether the prosecutor is willing to dismiss it at that point. I leave that to them. I mean, I don't care.
Can he ask
Most
for
of them do.
review after 5
Yeah.
years? Or-
Yeah, as long as he's got everything done, there have been no violations within the preceding 90 days.
Understood.
All right, you got it?
If you want a violation within 90 days of the 5 months.
You can apply for early discharge and then talk to the prosecutor about dismissing the case, okay? All right?
Yep.
Good luck.
No,
Abraham,
thank you, Judge.
Thomas Patrick Abraham, 24W833005.
Good morning, Your Honor. We should be bringing back my final approach. Do we want to get that estimate?
Yeah, call Jessica in.
She can hear that in like 30 seconds.
Yeah, I know, she's great. Your name, sir?
Thomas Abraham.
All right, so we set a sentence for today. He has been struggling. This is with regard to the show cause dated October the 9th. And I have another one here. Yeah, I'm not sure. What do we do on this? I don't,
We've adjourned, I mean, he submitted responsibility, then we had adjourned to
I
set.
don't think he admitted, did he?
Yeah, there was a moment where we had to go through just clarification, but yeah, he's admitted,
All right, I gotta refresh myself. Your name?
That's going
I said a sentence on this. He's got 5 counts here. Did I take pleas to all those counts?
I believe so, yes.
And I didn't write it down?
Yeah, you took pleas to all counts. We did dismiss count 1 though.
Okay.
That's what I have listed from the last hearing, which was October 16th.
that's accurate.
All right, I need another probation violation sheet here. Like something happened. All right. So you're saying count 1 was dismissed as part of the show cause of October the 9th. It was scheduled for the 16th, 1 week ago, right?
Correct.
Then defendant pled guilty. Just give me 1 second, please. So count 1 was dismissed. I'm going to prepare a register because obviously if I did, I didn't do a very good job. Oh, wait a minute. Wait a minute. Wait a second. Wait a second. I see what happened. All right, my mistake. He pled guilty. This just didn't get stapled to the register here. Count 4 was dismissed on your motion.
That's correct.
I accepted the plea to count 1, 2, 3, and 5. That was cocaine metabolite. Number 1 was a positive test for cocaine.
That's correct.
Count 2 was a positive test for a cocaine metabolite. Count 3, failure to refrain from consuming alcohol or drugs, positive for cocaine. And count 5, failure to submit to testing is ordered on September 30 of 25. Why did I adjourn this a week?
Under the circumstance, I asked for 2 reasons. First, to show that he was going to continue to test negative, which he did reflect 7 negative tests. And secondly,
He tested negative?
for the last 7 tests, yes, Your
Is
Honor.
that right?
That's correct. He appeared for test and every test was negative, and that's 7 tests since October 5th that he appeared for.
Okay.
And another issue that the court took into consideration, which we were very thankful for, was my client was closing on a house that he was able to successfully do on October 17th.
So, okay.
And I had further elocution.
Did we talk about sobriety court?
Did the team voted on?
Yeah.
It was, I think, regarding count 1 being the fact that he brought in outside urine
Yeah.
for that test, and that was regarding why he was.
And what do you want to say?
Your Honor, I will note on the positive that he is reflecting a negative test. He is in the guidance center 3 days a week. He is attending AANA 3 to 4 times a week, seeking a sponsor. Judge, he's dedicated father at this point to his 3 adult children, 34, 31, 27. He's also dedicated to his grandchildren at age 13, 9, and he has another grandchild due on November 11. I work with his CDLA and assist in tree removal. Judge, he discarded all the toxic friendships and relationships he had that were adding to obviously his questionable behavior, but I know a little bit later than we would have anticipated or wanted him to start, but he's starting to accumulate some success in his sobriety, and is anything that we can do to help encourage it would be greatly appreciated by the court. As I indicated, my client's not working. He's retiring for 29 years as a Delta bag handler, which I think did lead to prescribed medications, which took him down this road. I'm just hoping that he's emerging.
Why did that lead to prescribed medication?
Well, he gets back injuries.
Okay, that's what I thought you were alluding to. That seems like a tough job. I mean, at least at my age. Okay, what do you think here?
So again, I think he was a good candidate for sobriety court. I really thought that was the best option for him, but considering that he won't be applied in it now, I am a little concerned just because being on regular probation, the testing and kind of some of the guidelines is not going to be as strict as sobriety report would be. And I worry with him that if we could especially lower testing down and things like that, he's going to start testing positive again, is my concern.
Your Honor, as far as regular probation, is there a way that you can have regular probation adopt some of the conditions of sobriety court?
We can't pay for anything. That's the problem. That's the problem.
As far as splitting the baby to at least sidestep the potential for time in custody or having re-screened for sobriety court. I mean, in the meantime, he's at least doing negative tests, but anything the court would like to consider, my client is more than willing to adhere to.
I mean, it's only 3 months old. Mr. Abraham, what do you want to say?
I'd like to say that I've got much to be thankful for and to live for. I don't want to go backwards in any way. I closed on the house. I've got a grandson coming, my first grandson, and I'm willing to, give him my best shot. I don't want to disappoint myself or you or the court. I just want to continue.
All right, I've heard enough. Let's adjourn this. Let's try to get him back in sobriety court.
You want to try that again?
I do. You pull any more of that nonsense with bringing in urine or missing tests. If you're not successful in the next 4 weeks, I'm not going to take you in sobriety court, and I'm going to send you to jail. Do you understand that?
Yes.
At least I'm starting to see that maybe, just maybe, you're showing a little bit of interest in getting off of that junk. Well, give me about 4.5 weeks, Lisa.
Do you want to do a sobriety court day?
I want to, we're going to set him back and see if he can try to get through the bond phase of sobriety court. You're to comply with all of the terms and conditions that they tell you to. And then we're going to set it out long enough where the team can evaluate to see how it's done and make a determination as to whether or not we should accept them.
Okay, November 26th at 8:30.
I think that's enough time. November 26th at 8:30. That's the day before Thanksgiving. So you do what you got to do. You go talk to Ms. O'Donnell. She'll set you up with sobriety court people, probation officers. We'll go from there. Go down the hall, get your notice. You're still on thin ice with me. You can't bring in urine. That's ridiculous. I mean, that alone causes me to say I should be sending you to jail. But at least you're, looks like maybe you're trying now. I'll give you the benefit of the doubt, but don't hold your breath. If you violate again, I'm telling you, Mr. Abraham, I don't want to threaten you. I'm telling you, you're not going to like what I'm going to do. Okay?
I should thank you.
Good luck.
Thanks, Judge.
Thanks, Mr. Shumke.
Yeah.
Thank you. Napoleon Chevalier Robinson, 24F243037. Mr. Robinson, what are you doing here?
Well,
I don't want to talk about it. You're charged with failure to refrain. Tell me your name.
my name, it's about your Robert.
You're charged with failure to refrain from consuming alcohol, testing positive October 6th. That is the charge. If you've had a technical violation, if you plead guilty or if you're found guilty, this would be a second. You could get 10 days. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights revocation of probation? If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Yes, sir.
You have the right to a lawyer. I'll be happy to provide you with one at public expense. Do you understand me?
Yes,
Do you want a lawyer?
yes,
I'll give you a lawyer. I'm entering a not guilty plea, indicating you stand mute. We'll let you go talk to the lawyer, and then the lawyer will come in and we'll handle this probation violation, okay? All right, sir, good luck. Samuel Lee Hill, 25W727451. Mr. Hill, come on up here, state your name.
My name is Samuel Hill.
On February 4, 25, I sentenced you. And now I have a charge here, and I took this under 7694A. I have a charge that you failed to attend and complete the domestic violence program with 12-week follow-up. That is the charge if you plead guilty. If you're found guilty, this would be a first violation. You could get 5 days. Do you understand that?
Yes, sir.
You got to keep your voice up. Did you sign the advice of rights and read and understand the rights?
Yes, sir.
Keep your voice up. Can you keep your voice up for me?
Yes, sir.
All right. If you plead guilty at any time, you're giving up all those rights. There will be no hearing. Do you understand that?
Yes, sir.
You have the right to an attorney. I'll be happy to give you one at public expense if you want one.
Yes, sir.
Would you like a lawyer?
Yes, sir.
I'm entering a not guilty plea for you, indicating you stand mute. We're going to give you a lawyer. You'll go meet with the lawyer, and then either way, you're coming back in front of me with your lawyer right now, okay? When you're done talking. Any questions?
No, Your Honor.
Okay, go talk to the lawyer, and then when you guys are ready, come on back in. Thanks. Do we have anything on that, Mr. Derby? Or did I? I'm sorry. I'll take it, Ted. Thanks. Donald Henry Dubry.
Yes, Your Honor.
Come on up to the podium. File 25G81175A, B, and C. Your name?
My name is Donald Henry Dubrow.
Mr. Dubry. They're going to give you an adjournment. Okay?
Okay,
To comply. Okay?
yes.
If I were you, I'd start going home and working on it today. I'm only forewarning you. I don't want to talk about whether or not you have a blight condition. You're still presumed innocent. This tells me we're adjourn it for them to schedule an inspection and make sure you're in compliance. I've had enough of people not doing these things with homes. You can't have rodents. You can't have a house that's not properly maintained in accordance with their codes. Do you understand?
I do, Your Honor.
And now you're gonna, and I don't want you coming in here in 2 weeks and telling me, well, Judge, it was cold out. You knew about this. This says there were numerous warnings. I'm giving you 2 weeks to get a good start. Lisa, and I mean that. I'm not gonna be very patient with you. This ticket says here on the bottom, has refused to respond to any letters or personal visits. Now, listen. They were too nice.
Yes.
They were too nice. Listen, let's start with that premise. They were too nice. I'm not going to be nice.
If I may, sir. The reason why he thought I was ignoring his warnings, because I was in the hospital
How long were you in the hospital?
5 days, and I didn't read my mail for at least 6 or 7.
Well,
Because by the time I got home,
they didn't just pop this on you 5 days ago or a week ago or 2 weeks ago. They've been talking to you about this, right? The city's notified you they have problems with this, right?
yeah, but it was a mailing.
Calling the prosecutor. I'm giving you November 6th. You have any kids?
No,
Get somebody to help you if you can.
it
Well, I mean, you can't let your house go like this. Adams is a nice street.
is very interesting.
Nope.
I lived there all my life.
Nobody wants to look at junk.
I
Right?
hear you, yeah.
Nobody wants to look at junk. November 6th at what time, Lisa?
9:15.
All right, counsel, your appearance.
Anthony Williams.
How long has the city of Gibraltar been asking Mr. Dubry here? By the way, the ticket's misspelled. It's Dubry, D-U-B-R-Y. How long have they been asking him to clean up the property?
I believe it's been a moment here.
How's a moment? How long's a moment?
I don't know the exact time, but he's assuring that by the next court date, he's going to clear out those tanks that we've been asking to clear out.
How long? You don't know who's here? Does somebody know? Is there a building
I
inspector?
have the sergeant here, we can find out the exact.
Call him in. I have too many of these cases going. You know that? I don't know why people don't take care of their property anymore.
Well,
Yeah, I'm not saying everybody, I'm not saying most, but more than I've ever seen are not. Let's just put it that way. So I'm gonna ask the sergeant, and I'm gonna find out, and then we'll go from there. But that is going to be your next court date, November 6th at 9:15. If you want a lawyer going forward and you cannot afford one, you can fill out a petition for a court-appointed lawyer. Do you understand that?
I do.
Okay. Because you're entitled to one at the arraignment, you waived it, but if you want one going forward, I have to have evidence that you're indigent, all right, that you can't afford your own anymore. So that's where we are with it. I think the sergeant's in there, right? All right, Sergeant, your name?
Here,
How long have they been notifying Mr. DeBry here to clean up his property? Do you know?
just over 2 months there.
Okay. Mr. DeBry, just make some strides, quick strides. You can start today. You can start tomorrow. You can finish it by Sunday if you want. Let's get it done. I'll see you November 6th. You can go down the hall, get your notice. Any questions?
No.
Good luck.
Thanks very much.
Thank you. Rise of Gibraltar LLC,
Thank you, everyone. Yep.
25G8682776. Your name?
Justin Weiss, member of Raj Gibraltar LLC.
Counsel, your appearance?
Scott Osnacher on behalf of Raj Gibraltar LLC.
This is going to be a bench trial?
Yes, Your Honor. Where I
All
would
right.
defer to prosecutor.
What is your position with Rise of Gibraltar LLC? You,
Member.
and I'm sorry, your name again?
Justin Weiss. He was the only one of the other members of the LLC.
Ronald Thomas. Did you say Vice?
Weiss, he is a boy.
And what do you do there?
One of the owners,
This is a corporation, true?
LLC.
Well, that's a corporation. Are you the president, vice president? What are you?
Member.
I don't know what that means. I mean, are you a shareholder? I really want an office holder here, Mr. Ossenmacher, but I'll take this waiver. You're authorized to waive this jury trial demand on their behalf, right?
Yes.
And do you understand that the company has constitutional right to a trial by jury. And if you waive that right, I'm going to be the one who will solely decide your guilt or innocence instead of 6 people that would be impaneled.
Yes.
Anybody force you to do that?
No.
If you can, and you would waive your right to a jury trial, right, counsel? Mr. Bologna?
Yes, Your Honor.
If you can make sure that you have these guys fill out these waivers in the future, that would be better. I'm going to set a bench trial, waivers accepted. We'll give you a bench trial date,
November
What do you-
20th at 1.
November 20th at 1.
Your Honor, could we get a little bit more time? We have a potentially complex defense that's going to require some investigation and extensive investigation into the history of this property, because we need to prove a prior legal non-conforming use, which may require us to track down.
You know what
multiple prior
agitates
owners.
me though a bit here? Mr. Ronald Thomas appeared on August the 14th. I told him he needed to hire a lawyer. We set it for the 28th. They didn't show up. We set it again for the 11th of September. They didn't show up. I said for the staff to issue a show cause against the president. So they've had here months that they've known about this. So I'm not going to give any more time. This is crazy. I mean, I don't understand why this president made me beg him to get a lawyer, and I'm not going to beg him. Sorry, it's nothing against you. November 20 at 1 o'clock. That will be the bench trial date. If you guys want a final pretrial date before then, I don't have a problem. I'll set it up then. We'll see how everything's progressing. If you want, if not, I'll just set it for a bench. It's up to you. I'll tell you what, Mr. Ossenmacher, when did you enter your appearance?
I entered my appearance on
October 9th.
Why did you guys play such a game with me? Mr. Thomas, I don't appreciate that. I don't appreciate that. I'll do this for you, Mr. Ossenmacher. We'll make November 20th, if that's the same time, Lisa. We're going to do it as a pretrial. I don't know if it's just an afternoon docket, if it's going to be a final pretrial. We can do
No,
it
we can do the
earlier.
morning. I just did
Okay.
that because I thought it would be lengthy.
I understand. What time should we do that?
9 o'clock.
At 9 a.m. And then I'm going to give you a bench trial date. I'll do that for you, counsel. That's not your fault that they were out of control as far as I'm concerned. Bench trial, that'll be the final pretrial. And then the bench trial date will be on,
Gibraltar's here December 4th and December 18th.
what do you want? What do you want, Mr. Ossenmacher? You want till the 18th? If you've got a defense, I have no issue. If you want, tell me the 18th. I'm fine with that.
the 18th would be preferable. I do have a conflict on my calendar on the 4th.
I'm sorry, you have what?
I have a trial tentatively scheduled.
No, that's fine. We'll do the 18th. Lisa, at what time?
1 o'clock.
At 1 o'clock, okay? 1 o'clock. All right, so you got to be here November 20th at 9. I'd like Mr. Thomas here. He keeps acting like he's the president or something. I mean, of the country.
We'll make sure
I
that
can't
Mr.
believe he
Thomas
acts this. What do I say? He's this aloof about this. I want Mr. Thomas here.
We'll make sure
Okay?
that he's there.
Yeah, make sure he's here. I'm not real excited with him. He's gonna have to show a slight amount of respect anyway. So he's gonna be here, okay? Tell him I want him here. You understand? All right, so November 20th, December 21st. It wasn't your fault, so I'm good with doing this. Have a good day. Thank you.
Thank you, Your Honor.
Norbert Pastor, 25T644584. Morning again, Mr.
Step up, sir, give your name to the judge. Got a deal on suits today, that never reversed.
Nice. It's good to see. I'm sorry, sir, your name?
Norbert.
All right, so we're going to adjourn this. You need discovery. I'm signing your order. So we'll set this. You want to set it on the, what would we give them on the other one, the 6th?
6 is fine.
That's
Sorry,
when
I was
you-
muted. November 6th. I think we did 9 on the last
Yeah, so
one.
we'll do this at 8:45. How's that?
Because I'm old fashioned and don't carry a calendar or something, I know there's a problem.
You'll call the court.
Thank you, Judge.
And you can get a stip to adjourn from the other side. No problem. Good luck, sir.
I'm done yet, Judge. I'm done with you, but I know you're done with me.
Take care.
Thank you.
Aaron James Harper. This is file number 24F243110A, 24F243110B, 25W838175, 25W838256, 24B1466691B, 25F244556, 25W839353, and finally 25B148510. Your name?
Aaron Harper.
What brings you here today?
So I'm on a payment plan.
Yeah,
I just wanted to ask for a small extension on the, or at least for the first week.
all right. Let me do this. Lisa, let's look at these files with Judge Hessen's name on them.
I have them all linked together. He's on 400 biweekly beginning 10/17.
But these other ones that had the bonds on them, were they
Those were third
applied?
party.
Who's the third party poster for you? Who posted?
Who posted the bonds?
Yeah.
My father.
Is your father here? Is he gonna let you apply the bond?
What is that?
You posted bonds, they're in his name.
Yeah, because those were, they were for a traffic ticket that, that got like older. I had to like pay a bond for instead of actually.
I got it. I get it. You ignored us for a lengthy period of time, right?
Yeah.
Right?
It was,
Right? What are you asking me to do here?
So
Just tell me what you're asking.
just like for,
You're supposed to pay $400 beginning
yeah, biweekly, yeah.
October the 20th, which you should have already been in here and talked to me on because I told you on it before the due date, but I'll let it go.
Yeah, it was supposed to be.
Just tell me what you want.
Just for the extension on the, payment.
I don't know what you mean. You want to start paying 400 when?
So I was supposed to, the first payment was for last week, but today I get paid tomorrow, Friday.
Yeah.
But it usually doesn't hit my card until around like 8 or 9 p.m. So I probably could like make the first payment either Monday or Tuesday.
$400?
Yeah.
Defendants pay $400 bi-weekly beginning October 28th. Talk to your dad in the meantime about maybe him applying the bonds and helping you. If he won't, he won't. Okay, on these other ones. So she's going to print you out a new sheet. You're going to have to be patient, okay? Lisa, print out another sheet for him, will you please?
What was the start date again?
The 28th. He said he couldn't
Okay.
have it till Monday.
Yeah, have
or
him stop
Tuesday.
down here. I'll reprint it.
Okay, go down the hall. You did the right thing coming in. Next time, do it earlier, okay? Good luck. And I need honor before the due date. Nicolean Chevalier Robinson, 24F243037. Mr. Robinson, your name.
It is Nicole, Chevalier Robinson.
Good morning, gentlemen. And that, Mr. Roberts.
What is he going to do?
Judge, you can't plead not guilty.
He wants a hearing?
Well, he's got a discharge notice signed by one owner and it's dated.
That's got to
September 29th. And the violation occurred on October 5th.
Can I see that? Does that have this case number on it? 24F243037?
I'm sorry, what is,
He was in front of me on another case.
was a
24F243037.
my apologies, Mr. Brown's comment.
Yeah, it's the other one he had in front of him. Does he still want a hearing? Is he going to plead guilty?
Yes,
Call in Jessica. If you plead guilty here, sir, I want you to understand this would be a second technical violation. You could get 10 days on that case. Do you understand that? On this case, do you understand that?
Yes, sir.
Did you sign the advice of rights?
Yes, sir.
Did you read it and understand it?
Yes, sir.
If you plead guilty, you will be giving up all those rights. There will be no hearing or trial. Do you understand that?
Yes, sir.
To the charge that you failed to refrain from consuming alcohol, testing positive For alcohol on an October 6, 25 test, how do you plead?
Guilty.
Did you consume alcohol, say, within 3 days of October the 6th? And was your test on October the 6th positive for alcohol?
Yes.
You consumed alcohol, is that true?
Yes, sir.
Anybody forced you to plead guilty?
No.
Please accept.
Just
You're-
for number.
I love how you come in so quick. All right, what do you have to say, Mr. Gay?
Judge, apparently this was an oversight by Mr. Robinson. He mistakenly thought that he was off probation and had consumed alcohol, not realizing that it was the brown occupation and not the flat.
But you don't even know when you're coming off probation. You're not eligible.
You have 2 cases, Your Honor. So he was discharged on his one.
I know, but this is 12 months probation. He's not off until February 6th of 26.
That's correct.
It's not like it's not like it was a week apart or something. I mean, come on.
Yeah, he was discharged on that other case September 23rd.
Yeah, I get it. Mr. Robbins.
I'm circling 2 cases, but I don't.
Well, don't get in trouble. Then you don't have to juggle even one. Right?
So.
What do you have to say?
He's compliant otherwise, Your Honor. I don't have any concerns for him. Everything else is completed. Victims impact panel is done, 8 hours of community service. Well, you had 2 separate, he had 8 hours originally and then 8 hours at his last violation. Both of those are done. All that's left for him, I do think he does have a little bit of a balance still, but he's been paying on that well. My only concern is that technically his testing was to be lowered to once monthly beginning in November. I would ask that he stays online for the duration, Your Honor. For the twice monthly anyway.
Anything else?
Judge, just that, I mean, to his credit, at least he's been honest and he's complied to the best of his ability with what was report. I would ask the board to chalk this one up to oversight on your part.
Nah, he didn't have an oversight. Mr. Robbins.
I'm like a little bit of leniency.
Mr. Robinson, you've come back in front of me a lot. I told you I like you. I don't know why you persist in testing my patience with you, though. You're going to serve an additional day on the court work program. There's a $35 a day charge for that. So you're going to serve 1 day court work, pay $35 for that, and you're going to pay $100 in costs, and you're going to test bi-weekly for the duration of the probationary period. You owe $135. Can you pay that today, or do you need time?
I need time.
Pay by November 6th. Can you do that?
Yes, sir.
I'll make it the 13th, just to be safe. Okay?
Judge, if I may, just so there's no other misunderstanding, when does Mr. Robinson's probation?
February 6th
February 6th.
of 26. You still got almost 4 months, and now you can't apply for a discharge. You really blew it. You could have been out of here. You could blow off this pop stand or whatever that thing goes. Good luck.
Give it to Judge.
I know. I'm a likable guy, right? All right, Joshua Michael Zarate. Good luck, Mr. Robinson. 25F243398. Mr. Zarate, come on up here. Tell me your name.
Joshua Michael Zarate.
Mr. Gabe,
Good morning, Judge, man. This was all right.
what's he going to do?
You're gonna pick your commission.
I need somebody for Beth. If you plead guilty here, sir, this would be a first violation. And your probation, not your probation could be revoked. I need Beth or somebody for her. You could get 5 days on this by pleading guilty. Do you understand that?
I do your part.
Did you sign the advice of rights revocation of probation?
Yes.
If you plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that?
Yes, Your Honor.
You understand all your rights?
Yes, Your
The
Honor.
charge you fail to refrain from consuming alcohol, how do you plead?
Guilty.
Did you test positive for alcohol on September 29 or 25?
I did.
Did you consume alcohol, say, within the 3 days preceding that?
Yes.
What did you drink?
Just beers.
Well, Beth's off. I need somebody for her. How many beers? Where? Where?
Oh,
It was at your house. Where was?
oh, it was at home.
Were you by yourself?
I was.
Nobody else there?
I live with a couple of people, but they work.
So what did you do? Go up to the store and buy beer?
There was just beer at the house,
Well, who put it there?
one of them.
I think it's roommates. That's.
Well, that isn't nice. They're not supposed, you're not supposed to be around alcohol either, you know. So you just went and started pounding beers.
Honestly, Judge, there's no excuse for it.
All right, good enough.
If I may, just as Mr. Zarati's mother was just recently admitted into a group home where she's suffering second dementia.
Oh, jeez, I'm sorry.
And
That's all.
turns out her husband, Mr. Zarati's stepfather, had been embezzling money from the accounts.
Nice.
Without his knowledge, and kind of, he's been getting calls from the home telling him that.
How can he embezzle money? What would he, is he on, he's not on the accounts?
To be honest, Your Honor, I'm not 100% sure about this about how he has been embezzling the money. I've just been told that he has been by the staff. She's like a financial advisor at the group home. She talked with my brother's wife.
Okay, you guys figured that out, but
That was the reason why the judge, she kind of fell off the wagon, so to speak. He's been getting a lot of calls from that group home, and his mother's been
you just put,
uncomfortable at that place, and she's been trying to.
you just went on monthly testing, right?
Yes. Starting, I want to say October 1st.
Judge, otherwise, I believe Mr. Zarati has already completed all of his other conditions, and he does have, out of the 1355 originally approved, I believe he's got a balance of 455 that's still pending. So he's made a good effort to pay off a substantial amount of that balance that he owes. That assure me that he's completed all of the conditions of his probation. Isn't that
All
right?
right, you've been doing well. Serve 8 hours of community service. That has to be completed by November 25th.
Okay, Your Honor.
8 hours, nonprofit organization, pay additional costs of 100, and you're to test bi-weekly during the duration of probation. Okay, you're gonna have to go meet with probation. John, tell them they don't have to come here. And you're gonna sit down, they're gonna change your color, and they'll answer any questions you have. Can you pay that $100 now?
Can't start tomorrow. I get paid tomorrow.
I'm just gonna say, pay this by November 6th, okay?
Thank you.
So go into the probation room, John, take them over there, and you're all set. Good luck. Bennett, Dakota James Bennett, 24W83485-3A. Mr. Bennett, your name?
Dakota James Bennett.
Good morning, Judge. My name is David Finn. You have to meet with Bennett.
I need Jessica. All right. Make sure they know they don't have to send me anybody on that last case. How's he going to proceed?
Judge, you got to plead not guilty. According to Mr. Bennett, he completed the 16 hours, which is the issue of data verification
Right.
by his probation officers that would be emailed to her direct.
He wants a hearing as to whether or not they sent it. Is that what you're telling me? If he does, that's fine.
According to Mr. Bennett, he's already spoken to probation officer, who was Mrs. O'Donnell, and she did assure him that the verification would be emailed. Is that correct? That's why he failed to provide it to. Verify that it was O'Donnell, then just.
Ms. O'Donnell, come on up here. Your name? Did we ever receive his proof of completion of 60?
Features for the community service, I actually gave him 2 different extensions. I gave him an extension till March 31st of 2025. And then he called me again and needed more time. I then gave him till April 30th of 2025. And then I issued the show clock after that.
All right, so do you want to have does he want to have a hearing still?
You must saw it.
I mean, I would like to find my case for it, yeah, because I went and did it.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
I figured so.
Okay, go ahead.
So I have 1 violation listed for the defendant. Number 1, failed to provide proof of completing 16 hours of community service by March 1st of 2025. Again, like I said, stated earlier, I gave the defendant 2 separate extensions regarding his community service. I initially gave him until March 31st of 2025 to complete his hours and turn them in to me. He then called me again and asked for more time. I gave him till April 30th of 2025. I have yet to receive any kind of proof since then at this point, and I haven't heard from the defendant.
Any questions of him?
Judge, no, I would,
Does he wish to testify?
no, if I may, Mr. Bennett's gonna change his plea, Judge.
Well, that's okay. I've heard the testimony. I'll go ahead and find him guilty as charged. I mean, there's no contrary evidence.
He, according to Mr. Bennett, Judge, if I may, says that he's got an email confirmation, but it's in his other email, which he doesn't have access to. I did advise him that he needs to have that today.
all I know is I went and did the hours.
Where?
I want to say it's called Victory Gym.
You don't remember?
It was long ago and I thought.
Do you do a lot of community service?
No.
Have you been in other courts?
No.
What do you want to say? I want to say it's Victory Gym a long time ago. This wasn't in 1896. This was 5 months ago. Come on. You called her up twice. You asked for an extension. She gave it to you.
Sure.
I don't know what you're doing here, but this is not do it as you feel like. Are you this irresponsible with your everyday affairs? Well, come on, don't tell me this nonsense. I want to say it was Victory Gym, like there's a question in your mind as to where you did the community service. Why don't you just admit, Judge, I never did the community service.
Did do the community service, so.
Okay. I'm finding you guilty as charged for, hang on. I'm finding you guilty as charged for failure to provide proof of completion. I'm giving you 2 weeks to come back here with your proof. Okay, listen to me.
This is what just.
Now you're dancing around.
Nervous and scared. I don't have the proof of it, but I know that I did. That's all I'm saying.
Let it finish, you'll understand.
You're going back to Victory Gym and you're going to ask them to give you proof of it.
Yes, sir.
Now, in the future, you need to be more responsible.
Yes, sir.
I just got done listening to her tell me that, and I gave you till March. Let's start it from the beginning. I gave you till March 1 to complete it. It was only 16 hours. I sentenced you January 22nd. She gave you 2 more extensions for a couple of months.
Yes, sir.
And now you come here and you're telling me, well, I want to say I did it at Victory Gym. Like, just admit that you didn't do it. Because when I tell you to do this and you come back with some cockamamie story with me, I'm not going to be a happy guy. I don't believe people should be lying in court. Do you want me to adjourn it so you can go get proof?
I'd like to try, yes, sir.
Okay, we're going to set a sentence date, November the 6th. What time, Lisa?
9:30.
At 9:30. Defendant to bring proof of completion. I mean, where do you work at?
I'm sure.
What kind of charge was this? I mean, I didn't even do anything to you. I was more than fair with you. I didn't even place you on probation.
No,
Yes, sir.
he didn't acknowledge that, Judge.
What? Maybe that was my fault. I mean, they encourage us, the statute says they're not to be on probation unless the judge departs and says reasons why. Let me see the screening. Do you have it?
I'm sure it'll be done.
Geez, I only fined him $884. Something was. Okay, at a .09 and a .10 and he's 27. I still. God, I didn't even make him do any of this. All right, that's what I'll do. Come on back with your proof. Okay? You must comply with all other terms and conditions of probation. November 6th, 9:30. Go down the hall and get your notice. Good luck. Thank you. Wait, what?
I don't have enough.
Thanks.
Thank you.
Thanks a lot, Mr. Gates. Did you have a lawyer, sir?
Yes, sir.
Who?
That was Mr. Crawford.
If he's ready, I can do that now.
The columns, see.
All right, let me know.
All right. I'll let them know.
Sarge, do you want to do the
Yeah.
votes from?
Yeah. If you want to go get them, we're ready. If you want to go get them. Almanza, Arginus, Alexander, Molina, Almanza. 255-415-142, first miss. This was the 22nd. We're going to issue a show cause on that case. Freeman, Nicholas, Chandler, the second. 25B14904 A and B. On the B file, he failed to appear. First miss, issue show cause. On the A file, civil infraction, default judgment is entered. Kyle Alexander Ellis, 25B149. 548 A and B. We'll issue a show cause on the A file, default judgment on the B file for failure to appear yesterday. Stephen Lee Miracle Jr., 25B148-937. Defendant failed to appear yesterday. I don't know what's going on with this. Bond was posted at the window. This guy is missed 3 times. Posted his bond on October 9th, 6,010%. Warrant to issue, bond to be forfeited. That's a third miss. Joseph Lee Danko, 25B149-486. Defendant failed to appear. This is a second miss. Failed to appear for show cause. Warrant to issue, bond to be forfeited. 3,010%. Nate and Sarah Consulting, 25S023-343A. I don't know if this is a corporation. It sounds like it. Maybe you can have Shane look. Lisa, and we'll issue a show cause versus the president of the corporation if it is one. If not, just against the principal. I mean, there's no Inc. or Corp or anything there like typical, but and we're ending a default on the civil infraction there. Tasha Marie Milliken, 25D646434A. Just wait. We'll issue a show cause. Jeez, and B, default judgment. You're like a little kid. What? People against Samuel Lee Hill, 25W727451. Good morning. Sir, your name?
Good morning, I'm Samuel Hill.
All right, so how's he going to proceed?
Your Honor, my client's going to plead guilty to going in violation of resignation.
We're going to need Jessica in here. Is that what you want to do, sir?
Yes, sir.
If you plead guilty, you could get 5 days. Do you understand that?
Sure.
Did you sign the advice of rights revocation of probation today?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
To the charge that you failed to attend and complete the domestic violence program with 12-week follow-up, how do you plead?
I plead guilty.
Did you fail to attend and complete the domestic violence program with 12-week follow-up?
Yes, sir.
Anybody force you to plead guilty?
No, Your
Did you ever start it?
Yes, Your Honor. I will not start it.
Peter Wilson.
I paid for it, Your Honor, and I just, been so busy with work and.
You
He
working
did
on
not attend yet, Your Honor. He had paid for it, had to skip for the 8, and I'll explain why he missed that date.
Go ahead.
Well, Your Honor, again, my client's hardworking and he's got 2 jobs. And he works at Kroger's and he works at maintenance, especially does a lot of concrete work, 70 to 90 hours. But more importantly, the sister was in a terrible car accident recently. It was a truck. I think she needed back surgery.
And we
Need surgery. And he was there to kind of support him. He's kind of lost track of that date. Once he missed it, he couldn't get started. He asked for reschedule, Your Honor, for December the 12th. The issue is that it's right at the end of his probation. So she's hoping to get it extended so he can enroll in the class.
I don't understand when I ordered you to do this in February. This is October. That's 8 months. You're about 8.5 months out.
Your Honor.
Well, why are you taking so long? I don't intend for somebody to do those at the end of probation.
Yeah.
To be honest, Your Honor, it's.
I want you to be honest.
with me, I had got a new car, you know, with the job.
You're a big shot, eh? They're giving you a new car?
No, actually,
You bought yourself a new car.
I bought myself a new car, yes, sir.
And then you,
You know, to get back and forth, you know, the house.
this is the opposite of not having transportation. So you had transportation. What was the problem?
Payments, you know, I was, you know, with my credit being the way it is, my car payment's $575 plus full coverage. I'm thinking they're paying close to $1,000 and, you know, helping out family.
So again, right, that's why he's working so hard. So, you know, because he's got all.
What kind of car did he get?
I got a 2020 Chevy Malibu.
But when you got bad credit, I mean, in Michigan nowadays, you end up paying easily $600-700 for that.
Man, listen, I get it.
Sure.
You have to convince me.
So the court understands his financial issue. So he had a high and imperative to work, get this second job, work as much as possible. And when his sister got hit and the family popped up, he's got really spun around, Your Honor, in terms of his timing and availability. Again, he's willing to do it. He knows he's obviously late to the plate, but he's just hoping to give him a few more weeks. He's signed up. He's ready to go. Everything else, he's on track, Your Honor. For those $355, he's going to pay $55 today. He'll get the money paid. That won't be the issue. Just a few more weeks so he can finish.
What are you doing? Praying? Ms. O'Donnell,
Just hold on.
what do you think here?
My only concern is that, so he was scheduled for this program back in August. He failed to show up in August, and then they re-changed it to October for him.
Alright.
He failed to appear in October. We've now changed everything. Now he is to appear in the next available class, which is December.
Now he's not going to be out probation.
He's not, and he's under that deferral status.
I'm going to cut you a break, but don't dilly-dally. I'm telling you, I'm going to extend your probation for 3 months until May 4th. You're going to pay additional costs of $100.
Yes, Your Honor.
You're going to pay additional probation fees of $60.
Yes, Your Honor.
You're going to serve 1 day on the court work program and pay $35 for that, so that's $195. I'm going to give you all the way. I'm going to give you all the way until December 1st to pay these, okay?
Okay, Your Honor.
And you're to complete the domestic violence program with 12-week follow-up.
Yes, Your Honor.
What's your question? Yeah.
So, the courtroom program, will it be on the same days? I work Thursday through Sunday. That is my main.
You could do this on Wednesdays.
Yes, that's perfect.
We still have one on a Wednesday for you,
Thank you.
okay?
Yes, Your Honor.
Review date then, please. We're gonna extend him. His current review date is scheduled for January 20th of 2026.
Oh, this is under 769, yes. My mistake, yes. Lisa, let's get a new review hearing date. Probably, let me just double check something here. The new review hearing date, Lisa, I guess,
April 29th at 9 o'clock.
April 29th at 9 o'clock, okay?
Yes, Your Honor.
April 29th of 26 at 9 a.m. Okay?
Yes, Your Honor.
You do that, you comply with all this, the case will end up dismissed.
Thank you.
Good luck.
Thank you.
Thanks, Crawford. John Michael Sharp, 25 W839021. Defendant failed to appear, warrant issue 213 cash or surety. All these are failures to appear for show cause. People against Tepe. B.L. Tack at 25M 556-223. He failed to appear for show cause. 225 cash or surety. People against Angelina J. Bella, 25F 244-041, 249 cash or surety, 25T 645-883. You know what? These were scheduled for today. I'm going to hold off on issuing these warrants until Monday. I'm going to hold off on these until Monday, Tabitha. Can you white out all of these, please? All of them. I'm not even going to issue a warrant on Angelina Vella or John Sharp or BL Tackett. So just white out all those for me, please, like I did on a couple here. People against Schmittling, Stephen Tyler Schmittling, 25B1477001A. This is second mess. 675 cash or surety. Booker, Charner. Booker the third, 25T 646052. Defendant failed to appear. Issue show cause on that one. People against John David Jacobs, 25M5971278 and B. I'm going to issue a show cause. No. Issue a warrant. This is the second miss on the show cause here on Jacobs. And then on file B, default judgment will enter. File A is a warrant. Allen Wesley Jones. 25G81172A and B on the A file. It's a building code violation on the B file. It's a building code violation. This is the second miss on both of these. Failed to appear for show causes, 2,010% on each of those. 2,010% on each of those. And then I also have William Benjamin Hart the second, 25T645474, A and B. On the A file. Second miss, failed to appear for show cause, warrant issued, 3,010%. A default judgment was already entered on the A file or the B file back on October 9th. Kahari Ewayne K. Juan Benson, 25T646256 A, B, and C. On the A file, we're going to issue a show cause. No, I'm not. This is warrant to issue. Second miss, failed to appear for show cause as well, 3,000, 10%. And on the B and C files, defendant was already defaulted on October the 9th. Okay, when we get something else. Oh, Lord.
Let's call the case, People versus Ayana Fenn.
This is prosecuting attorney for the people.
Ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, King Wigan, on behalf of Mr. Ernest Finn.
You said Ariana or Ayana?
Which one did you say, Ryan? Ryan or Ariane?
Ayana or Ariana?
I said Ayan.
Oh, okay.
Ayana. What, I got another one?
Yes.
I have Ariana.
And I have Raya.
You have who?
It's a family spree. Don't worry about it. I have Ayana. Is that you?
Mm-hmm.
I got that, but is that?
Mm-hmm.
Okay. All right. Now that I have the right person, state your name for the record, if you would, ma'am.
Ayana. Finn.
Thank you. All right. What are we doing in this case? What?
She's Ian.
Mm-hmm.
I have Ryan.
I don't know why
You have who?
like this, but it's AYANN.
Oh. So that's spelled right?
No.
So how about the case number?
So
What
there's
case
a
number?
spelling error at one point.
My fault.
No, who is this? I don't care whose fault it is. Who do I have?
Ayana.
I am. That's
That's
and that is
Yes.
that's
Okay.
Mr. Brown's case. As
So
we
we
have
have a misspelling.
answer in a couple weeks.
I do, Judge.
Okay. So probable cause conference November 6, 2025, 9 a.m. Final continue.
Thank you very much, Judge.
Thank you. Take care, Mr. Williams. Court calls case People versus LaShawn Charles.
Letter assistant prosecuting attorney for the people.
I'm telling you.
I was just gonna, I told you how I'm gonna handle it. I'm just waiting. I'm not in, I don't know where you went, but I'm not going, I'm just.
I'll be here all day, so.
That's right.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Charles, who appears via Zoom. Ms. Charles, can you state your name for the record?
LaShawn Charles.
Thank you, ma'am.
Your Honor, we are asking for an adjournment. We're still waiting on some additional conversations to happen regarding this case.
Adjourn this matter November 13th, 2025, 9 a.m. Bond continued.
Thank you.
All right. Thank you, Ms. Charles.
Yeah, you're welcome.
Court does call the case of the people versus Dominic Kelly Payne.
That's about the people.
Dominic, would you state your name for the record? Dominic Kelly Payne.
Thank you.
Judge,
He's waiving.
Yes, Judge.
Sir, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right?
We do.
Preliminary examination having been waived, defendants bound over on a single count.
Your Honor, we acknowledge receipt of the information, waive its reading. My client would stand mute.
Defendant every way form of reading standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
November 4th at 1:30 with Judge McNally.
November 4th, 2025, 1:30, Judge Compton.
Thank you, Judge. Just for the record, he's already in Judge Kunke's recovery court. We hope to get this matter in there.
Got it. All right. Take care. Good luck to you, sir.
Thanks, Judge.
Bond continued. Court does call the case of the people versus Andrew Tennant.
Thank you, Your Honor. Good morning.
Morning. You're in the right spot, kind of.
Oh, he's on Zoom. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Tennant. Mr. Tennant, can you state your name for the record?
Andrew Scott Tennant.
Thank you. The court should have a waiver.
Waiver.
Yeah.
And sir, you're waiving your right to a preliminary examination?
Yes, I am.
All right, you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
Okay. People also waive their right.
Thank you.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Thank you. Your Honor, we acknowledge receipt of the information. My client would stand mute.
Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial will be set for
November 4th at 1:30 with Judge McNally.
November 4th, 2025, 1:30 before Judge Compton.
Thank you. And if Mr. Kennedy could place on the record, there was an offer extended for the waiver. So I just want to make sure that that's clear on the record for Mr. Tennant.
Yes, that is true, Your Honor. The offer was to, once bound over to plead count one of children in costume for criminal purposes. The sentencing agreement is 1 year in Washington County Jail, followed by 5 years in probation, additional conditions, including second prison, mental health care. By probation.
And count two would be dismissed.
That's correct, yes.
Yes.
All right.
Thank you.
All right, very good. Thank you. Thank you, Mr. Tennant.
Thank you.
Court calls the case People versus Andrew Gendy.
That's both the people.
Good morning, Your Honor. Andrew Santa, attorney for Mr. Gendy.
You'll have to move to that side. He's got to come up on the side.
Your Honor, I have a signed waiver here. Mr. Gendy, I need your signature there and there.
So he's waiving his right to.
Yes, Your Honor, we're waiving our PCC.
All right.
Thank you.
Sir, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offense is alleged or the offense alleged was committed and that you committed it?
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendants bound over on a single count. You acknowledge receipt of the information, Mr. Fanta, waive its reading,
Yes, Your Honor.
Yes.
and your client stands mute at this time.
Yes, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
November 6th at 1:30 with Judge Slay.
November 6, 2025, 1:30 before Judge Slay.
Judge who, Your Honor?
Slay.
Thank you.
I'll let her know you said who. Anyway, never mind. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Joshua Cook.
Assistant prosecutor.
Yep, I knew it was gonna happen. No, it's not. It's not. No, Miss Apple, you're good. Where's Janaza? It can't be me. It just can't. Where is Janaza?
What do you understand that you're doing on the case? He's gonna waive it to circuit court. Okay. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Cook.
Oh, no, hold up. Here she comes. Here comes the queen. She is, so she's gonna go to the podium. Judge, you just wait. I'll be there. You gonna set your appearance?
Circuit.
You ready to waive now?
Yeah, I'm just gonna wait because they're waiting on the observation violation case.
Okay. Your Honor, can we pass this? He's decided he wants to waive, so I want to get the paperwork together.
Oh, you want me to pass it?
Please.
So we had to wait for you to show up.
I know.
You know that Mr. Brown could have done that. We didn't need to, okay, fine. I'll pass it.
Thank
We'll
you
get
so much.
back up, sir.
Come on. In at the bottom or screen signing Minnesota.
From Minnesota. Court calls the case of People versus the John J. Wright.
Trevor Maple for the people.
Tina Sachs on behalf of Anjali, right?
I think they dialed in. Okay, we dialed in from Minnesota. Okay. She stated her name. All right. You're asking for an adjournment?
Yes, Your Honor, I'm still waiting on discovery.
How much time do we need to?
3 weeks.
Standard 2 weeks? So, really? Okay, so you want the 13th? Will that work for you?
We'll work quickly, Judge, yes.
Probable cause conference, Mr. Wright, will be adjourned to November 13th, 2025, 9 a.m. Bond continued.
Okay. Thank you, Your Honor.
All right. Thank you, Ms. Wright.
Thank you.
Court calls case, People versus Trita Guyton.
Trevor Maple for the people.
Good morning, Your Honor. Mary Rubio on behalf of Ms. Guyton. I'm standing in for David Burgess with his permission. Is that correct, ma'am?
Yes, ma'am.
Okay, please state your name.
Treat a guy. Good morning, Mr. Simpson.
Good morning. All right, you're asking for an adjournment?
Yes, Your Honor, we were just recently retained. I also would like to address bond when it's appropriate.
Probable cause conference will be adjourned to November 6th, 2025, 9 a.m. Yes, as to bond.
Your Honor, it is my understanding that Ms. Guyton unfortunately failed to report to community corrections, and that's what has her in the situation she is in today. But I wanted to indicate a couple things. She indicates that she did call twice early on in October, and at that time, on 2 different days, she was told they did not have the paperwork and that she needed to call back. Ms. Guyton openly admitted she did not try to make any excuses. She said to me that she simply forgot. Ms. Guyton, unfortunately, has been diagnosed with lung cancer. She has received 1 round of radiation treatment. They have found another nodule. She needs to get more treatment. She's 63 years old. She also suffers from blood clots in one of her legs. I'm asking that the court would consider reinstating her bond. She understands the importance of complying with all terms of her bond, and she knows that she needs to follow up with community corrections.
Any response?
Your Honor, I want to note that my office did intend to extend a misdemeanor offer in this case. When we're looking at the ex-jail file, it looks like she has a couple of different holds, one on a case that was pled to RNO attempted, as well as a minor misdemeanor hold out of Canton. Nothing else.
I'll grant the defendant's motion. Her bond will be modified. I'll reinstate the previous bond as set. Defendant needs to report over to community corrections. We'll need to prepare a new order for testing. You understand that, ma'am?
Yes, sir.
Thank you.
Thank you, Your Honor.
That's called the case people versus Antonio Cornelius.
That's about the people.
We're ready in that matter, Your Honor. Ron Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Cornelius. Your Honor, I believe this matter was stipulated for an adjournment.
I don't have a stipulation. Is he here?
No.
Well, I wouldn't have signed the stipulation because I got a bond violation in any event.
Okay.
So what do you want to do?
Your Honor, I would ask for a show call, but that's Mike Gaddy's thing, so I'm going to ask for an adjournment instead.
Well, I don't know what he's doing or not doing. Well, I see what he's not doing. He's not testing. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000 cash surety. That warrant will issue immediately.
Your Honor.
Court calls case People versus Alicia Allen.
That's about the people.
Ready, Judge?
At the podium, please state your name for the record.
Alicia Allen.
Thank you.
Thank you, Judge. We are requesting an adjournment on this matter for further negotiation, and Ms. Allen would like me to address bond, please.
I'm sorry?
And Ms. Allen would like me to address bond.
Gonna do it herself?
I think she wants.
She doesn't need you.
No, she doesn't really need me.
Okay, I'm just, okay. But, all right. What I will do, I'll adjourn this matter out to November 6, 2025, 9 a.m. Yes, as to bond.
Thank you, Judge. I believe Ms. Allen currently has a $35,000 bond. She is requesting of the court that the court consider a personal bond on this matter. She indicates that she is in or was in outpatient treatment prior to being incarcerated. She does hope to get this matter resolved. In the alternative, I am going to be requesting a release to treatment if the court is not inclined to grant her PR bond.
Response?
Your Honor, this is an OWI third. Her priors are from 2019 to 2024. At the time that she was pulled over by the police, she had previously crashed into at least one vehicle while traveling between 50 and 100 miles per hour on eastbound I-94 from Jackson County, coming into Washtenaw County. A 13-year-old child was also in the vehicle with her while she was operating at a .118. There is an RNO causing injury attached to this as well as another RNO. I do not believe any change to bond is appropriate. I would even be concerned with a release to treatment given the allegations here and the lack of compliance with lawful orders. I would ask that the court continue the bond as currently set, and we can revisit a release to treatment at a later time. But I am very concerned about her being out of custody in any way, shape, or form in this way.
Anything additional, Mr.
No, Judge.
Given all of that, motion for bond reduction is denied. Bond will continue.
Thank you, Judge.
Court does call the case People versus Amiri David. You know, your name, sir.
Mary Davis.
All right. Take your hands out of your pocket. All right. I have PD, but I don't have, nobody got assigned to them.
This case also involves
It's Aaron Davis.
Aaron Davis, yeah. So we have Aaron Davis, but we cannot take Mary Davis.
Okay, but I don't have an attorney. I mean, the last,
Mr. Aaron Davis with Mr. Quinn earlier.
Aaron Davis was Mr. Quinn.
Mr. Quinn is here.
That case is already been called and Mr.
I know. What I'm indicating is so that wouldn't be a conflict for the PD.
Was he appointed or did he retain?
I have no idea. All I know is it was Mr. Quinn and not the PD's office on that one.
Aaron Davis, this is Mary Davis. Well, so we did review it. Aaron Davis was first appointed to us, so we asked to keep that one and have the others, Williams and Amiri Davis, as conflicts. It appears then that Aaron Davis has retained.
I don't know if did he retain?
No, he was appointed by.
I got switched.
So whatever happened. But,
all right.
So here's what I'll do. You guys get this worked out however it's supposed to work out. But the problem is going to be is now Mr. Quinn's going to have a problem even if you tried to switch because.
So what we can do is now we can keep Mr. Amiri Davis, I believe.
Okay.
And then
if you can do that, then
we'll ask for an adjournment to be able to.
I'll set this on the same date I set the other one, November 6, 2025, 9 a.m. Bond continued. Thank you.
That was just.
Court calls the case cases of the people versus Robert Barnett.
Thoughts from people?
Assistant Blood Center Liba for Mr. Barnett. Mr. Barnett, could you state your name, sir?
Robert Michael Barnett.
Andrew, we're going to be requesting an adjournment. Additionally, would like to address bond.
Probable cause conference will be adjourned November 6, 2025, 9 a.m. as to bond.
Thank you. With regard to bond, and Ms. Barnett is currently being held on 2 matters. Based on my review of the police reports, it appears that those 2 matters arise out of the same incident. I don't know if the prosecution would disagree as to that. So be asking for one of those bonds to be reduced to a personal bond if possible. Additionally, I did discuss the prior.
Why would that? I don't follow what you're saying. Why would that say there should be a personal bond?
Your Honor, can we approach for a moment?
No, I don't need your approach. I just don't understand that.
Your Honor, so 2 of the offenses appear to be one incident that were inadvertently charged as duplicates. So to be requesting for one of those bonds.
So you're saying that one's a duplicate?
Yes.
So he doesn't really have that case. Do people agree on that or?
This is first I've heard, Your Honor. Mr. Lebo and I did not have a chance to discuss that before the matter was called. I don't know. I would have to double check. I'm not 100% sure. I would indicate though that at the time that the possession case got picked up, which is 25F55793, he was in bench warrant status for the receiving, concealing stolen motor vehicle. So I would be opposed to any change of thought as he previously failed to appear on the pick up the case.
Andrew, I did want to address the previous failure to appear.
Okay, I see that it looks like the case ending in 1406 and the case ending in 965. I don't know if they are or if there were 2 motor vehicles, but they, on the face of it, could be.
They could be.
But I'm not going to have. One says a pickup truck, the other specifies a Ford F-250. But I don't know that they're the same. Mr. Lebo, you had to talk to counsel about that. They can't be surprised by that.
Yes, sir. And I did send an email. My understanding is that they may have reviewed that, but I believe that the email may have gone to a different prosecutor.
Okay. All right. What's the other explanation regarding?
In regard to failure to appear, Ms. Barnett has admitted to me that he was suffering from fairly severe substance use problem at the time. He tells me that he has since completed treatment at Share House. And he attends meetings on a bi-weekly basis, or rather a twice-a-week basis. Says he is very eager to have an opportunity to be released to prove to the court that he will be showing up in the future, and we would have no objection to a tether.
We do agree with you, because we'll get one dismissed. They do agree with you.
Okay. All right. So there'd be only 2 cases, but all right.
He was still in bench warrant status at the time, so I would be opposed to any change of bond.
All right. Because of that, motion for bond reduction is denied. Bond will continue on these matters.
Thank you, Your Honor.
All right, thank you. Court does call the case, recall the case, People versus Joshua Cook.
People.
And Assistant Public Defender, Chauncey Terry Action Ruling, on behalf of Mr. Joshua Cook, Your Honor.
Your name, sir?
Joshua Cook.
You're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and you committed it.
Yes, sir.
You understand you'll not have that hearing, you'll proceed to second court for further resolution.
Yes, sir.
You will also waive the right.
Yes, sir.
Preliminary examination having been waived, defendants bound over on a single count. Second round.
Your Honor, we do acknowledge receipt of the information, waive its formal reading, stand mute to the charges, asking the court to enter a not guilty plea on his behalf and set this matter for a pretrial.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea pretrial in this matter. Keep that for
December 16th at 1:30 with Judge Simpson.
December 16th, 2025, 1:30 before Judge Cumpy.
You're in front of country now, right? You're in front.
Bond will continue. Thank you.
Thank you so much, Your Honor.
Thanks, sir.
You need a few- thank you.
He needs to sign off.
Yeah.
Court does call the case People versus Jason Smith.
Is that on behalf of the people?
Morning, Your Honor. Kristen Saxon for Mr. Smith.
Okay, he's refusing to come up.
Yes, Your Honor, which is unlike him. I just spoke with him last night and another time before that, pleasant conversations. I'm not sure what's going on here. We were going to ask for an adjournment anyway because we're still waiting on some discovery.
All right. Probable cause conference will be adjourned November 20th, 2025. 9 a.m. bound continue.
Thank you, Your Honor.
Court does call the case People versus Charles Davis II.
Trevor Mayville for the people.
Mr. Davis, what do you guys do? What do you guys do?
He said there's one on the video.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Davis. Mr. Davis, state your name for the record.
Charles Davis.
Thank you, sir.
Your Honor, I believe today's the date and time set for the probable cause conference. We do not have all of the media, so we are waiting to get that.
All right. Is that going to be sent over?
I beg your pardon, Your Honor.
Is that going to be sent to them right away or?
Yes, Your Honor, I've been in touch with Mr. Feaster regarding this. We have provided discovery, but I think we're going to look into a second round.
Got it.
Be missing. We should use a couple of weeks.
Probable cause conference will be adjourned November 13th, 2025, 9 a.m. On continued. All right. Thank you, sir.
13th, okay.
Court calls the cases of the People versus Mohammed Murphy.
Judge Phelps to the people.
Assistant Public Defender, Chauncey Terry Action Ruling, Your Honor, on behalf of Mr. Mohammed. State your name for the record, sir.
Muhammad Murphy.
Thank you. What are we doing? They were having a conversation.
Your Honor, we would like to set this matter for preliminary examination, and we'd also like to address bond.
Oh. This apparently doesn't carry over there. Mr. Kilowatt, I think one of these cases are yours.
Oh, yeah, that's true.
Sorry. Mr. Mohammed Murphy?
Yeah.
Yeah, I know that's you, but on case 1701, you were.
I'm not aware of it. If you say.
Well, that's apparent. I'm informing you, I signed the order that the PD's withdrawn on that case and it's you.
You know what? It's my lucky day.
Good morning.
How you doing? Do you mind if I ask for an adjournment so I can talk with you at the jail?
How long that's gonna be?
Well, we'll get it as quickly as possible, Judge.
No, I would rather handle this today.
Well,
Because he said that it's been withdrawn.
okay, hold on one second. Nothing's, all this.
I just want to go home.
Judge, I wonder if we could pass this. I can go see him in the lockup.
Please. Okay.
You being considerate, Judge, you are.
Thank you.
Do you have any objection to that, Ms. Second?
Absolutely not, yeah.
All right, thank you. Okay, I'm gonna pass your case. They'll come back and talk to you.
Okay.
We'll get it all sorted out.
Thank
You're welcome.
More than one thing. What do I?
Court. Good job, Killerwald. Court calls the case, People versus Jason Campbell. All that did was postpone the inevitable. It's not.
The water system is probably the alternative.
Campbell.
Warren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Campbell. Like to determine.
Your Honor, I spoke to Ms. Deduce about this matter, and she was going to be asking for an adjournment. Mr. Campbell has a release and treatment order, and he is currently at the hold in Westland. He's set to be arraigned on that, I believe, November 6th. So both sides are hopeful that he can secure his release there, get to treatment, and then once he completes that, we can hopefully resolve this matter.
Kevin Daddish on behalf of Mr. Campbell, Your Honor. Everything that APA Overwater said is correct. Believe November 6th is his arraignment date.
He has a date in Westland, November.
A Zoom arraignment that we've set up for him here in Washtenaw County Jail. We've sent in the order was signed. He's also signing himself up for the Dawn Farms in.
I'm already in
Yeah.
yeah. Okay.
We're just adjourning to track that and pursuant.
I guess my issue would be if I set it for the 6th, are we going to be able to do both? Or do I need to kick this out to the 13th? Would
Perhaps
that be
the
more
13th.
productive?
That will be more productive. Anyway, if he gets arraigned and gets released, then
He's on that, and he's going to be looking for treatment here, so we can track it up.
Exactly. Yeah. Thank you, Your Honor.
Probable cause conference will be November 13th, 2025, 9 a.m. Found in this matter will continue. Thank you.
Thank you. I'll make the meeting. Okay.
Court calls the case, People, well, is he in? Got it. Court calls case, People versus Joshua Wara.
Government vote for the people.
Mr. LeBeau's case. Wara.
Joshua. Thank you, Your Honor. Mr. Warren, please state your name, sir.
My name is Joshua William Worrell. I'm representing myself in this case.
So you don't want to be represented by an attorney?
No.
Okay. All right. Well, I would say there come some perils with you representing yourself. You understand that, sir?
No. I know.
You
the
don't
mission
understand?
I'm a jailhouse lawyer. I know what I'm doing. You are working.
I'm sorry?
You are being paid by Adolph Mack to fry me. This is conspiracy for murder. Your wife, Delphia Simpson, came up here pretending to be Ann Arbor Comprehensive Care Center yesterday. You are originally the Tux family. You are an Egyptian lord. You're Illuminati. If you do not help me,
I'm Illuminati.
I will sue you and criminally prosecute to the fullest extent.
Okay, I welcome that. You're invited to
Thank
do
you,
so.
Judge Simpson.
What do you want to do with your case today?
Ellen Wara, Adolph Mack, Jeffrey Peak, Cynthia Miller, Frank Stanton tried to set me up, along with Derek Miller and Ryan Miller.
Okay,
They're
but
the
I've got to
Ku
do
Klux
something. I got to
Klans.
do something. I got to do something with your case.
Huh?
I've got to do something with your case. What do you want me to do?
I would like to sue, and what am I in court for today? And I would like to prosecute to the fullest extent.
Okay, so
And
let
I
me
can
do
sue
this.
for
If
10 times the amount of what was stolen from me. They stole $666.8 million from me. They then turned it into $5.5 trillion. and then put a hit out on me. I legally can sue for 10 times that amount, which would be $550 trillion. And I can criminally prosecute to the.
No, I'm with you.
Which is
I'm
my
with you.
right.
I did the math too. Listen, here's the thing. I have to advise you, because if you are going to represent yourself, what you're here on, okay?
I'm doing it over Zoom.
So you're here on a complaint that alleges that on October 15, 2025 on South Main Street
Pentagon's
in the
using
city of
prism
Ann
to
Arbor,
make the
Washington
Zoom,
County,
mess up.
that you failed to stop at the scene of an accident regarding resulting in serious impairment or death. Do you understand that charge?
$1 trillion?
Yeah, sure. And that's a felony, punishable by up to 5 years incarceration, a $5,000 fine plus court costs.
Which is actually 10 times the amount, because I can sue because it's conspiracy to murder, and sovereign law would make it 100 times the amount, but since it is conspiracy to murder, sovereign law.
I'm with
does
you.
not
I
exist.
got you. I just have to let you know what you're charged with.
I can sue for
There's
1,000
also
times the
count 2
amount.
on the complaint that alleges that on that same date and at that same time, that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yes.
Okay, so there are serious perils representing yourself as opposed to having counsel. I would just have to advise you, you'd be treated the same. You are charged with making sure that you have an understanding and that you abide by the Michigan rules of that you abide by the rules of evidence and the rules of procedure. You understand that?
Yes, Senator Simpson.
All right. And the other thing that I have to advise you of is that at any point during these proceedings, you wish to have counsel.
No, I do not want any counsel, and I want a bench trial, not a jury trial. Because a bench trial is
If at any point you do,
on objective evidence.
if at any point you do want counsel, you just have to let the court know and the court will make sure that you have counsel.
No,
You
I do not
understand
want
that?
counsel.
Okay, so what do you want me to do with your case today?
I
Now
would like
that
to
I've
do a
gotten through
bench
that
trial
part.
because a bench trial is on subjective
bench
evidence
trial?
and a jury
Well,
trial can
that's not
be
gonna happen.
bribed. And they're trying to.
Okay,
bribe the
you
jury.
can go to circuit
I
court and
want
have a
to
bench trial.
prosecute with sovereign law, and it's conspiracy to murder, and Donald Trump and Elon Musk are involved, and I can sue for 1,000 times the amount, and sovereignty
Your Honor,
does
if I
not
can
exist
if I
because the
can-
amount of money that.
I
they
don't know,
put
I've
that
not been
they
very
want
good at
on
it,
me,
but.
And Donald Trump and Elon Musk and Adolf Mack and Doug Minkoff and Jeffrey Peake and Ellen Wara all have estates that and residencies in states that do apply the death penalty. I would like to get.
Okay, I'm with you. I got you. Let me hear from somebody else real quick.
Your Honor, if I was working with Mr. LeBeau on this file, I was going to be asking for an adjournment as this is a new file. The defendant is on surveillance video at the intersection of this crash causing this accident and then fleeing the scene. That has not been provided to either the defendant or his attorney if he has
I'd like to
one.
get
So we would
Donald
need
Trump
more
to
time. The defendant's on parole, and if he's entertaining the idea of representing himself, I think it's important that we refer him to first.
Well, I don't know that I can do that right this second, although maybe. But here's what I'm gonna do. Sir?
Frederick Simpson.
I'm gonna adjourn your
I do
case
not want a
out.
jury trial. You cannot adjourn this. This is a high profile case. Where I can't, again.
Okay, but you
There are
haven't
too
seen
many
the
people involved.
You
have a
haven't
Neuralink
seen.
in your brain and you are being manipulated and bribed and conspired against for murder by the Nazis. You will work with me.
Alrighty then. So you don't want an adjournment?
No, I do not want an adjournment. I want a bench trial.
Okay, so
And based on
listen.
factual evidence, the jury trial can be bribed.
I hear you. So the only thing that can happen is I can set this for a preliminary examination, but you haven't seen all the evidence.
I don't need all the evidence. I know all the evidence. Let me get a discovery
Okay, then.
packet though, so I can represent
So-
myself though, please, with all evidence. I would like to see.
You want to represent
all records
yourself.
and all evidence.
All right, listen. Okay.
I would like to
So you want this
subpoena
set for
Bill
preliminary
Warren.
examination?
I would like to subpoena Bill Wara. I would like to subpoena Scott Casey, the Michigan militia, all of their phones, Doug Minkoff, Jeffrey Peak, Adolph Mack, Donald
We're not
Trump,
bringing all those people
Elon
down.
Musk.
Yeah, okay. If you want to subpoena them, then you can. But I'm not bringing all those folks. You want, my problem is he's asked for his exam. So I will have to set it. I wonder who'd like to hear this.
Your Honor, would we still be on the case?
Hang on, I'll get to that in a minute.
Thank you, Your Honor.
So I'm gonna indicate he doesn't want his discovery. Says he doesn't need it. Would they, man. I'm not gonna have the complaint that's rights have been infringed, so yes, I'm gonna do it. And you're gonna be mad. It's okay.
You don't care about my feelings.
I don't care about your feelings because you don't care about mine. But we shouldn't air this in public. No, I have to do the, no, I can't. I cannot. So I have to do it. I got you.
Okay.
I hear you, but I can't do that. So here's what I'm gonna do. I'm gonna set this for defendant invoking what he has. Would prosecutor have their witnesses available the 28th?
Yes, sir.
Sir, I'm gonna give you your preliminary examination. So your preliminary examination will be set in person on.
Your Honor, I'm so used to just
And,
saying, yes, sir.
No, I know, but I realize it's close.
With Carol Conkey and East Hope, et cetera, et cetera.
Excuse me?
Carol Conkey is involved. She is at 22nd Judicial Circuit Court with Feiger and Ellen Warren and Jeffrey Peak. Elon Musk is with Trump at the Michigan Supreme Court in Lansing. I do not want to adjourn. I want a bench trial.
I am not adjourning. I'm giving you the quickest preliminary examination I possibly can.
Yes, sir.
But I have to hear from all sides regarding that. I would set it for the 28th. Counsel, most of these witnesses are police witnesses, so we could at least begin.
Okay, thank you. What's today?
That's a yes or no.
Yes, sir.
Thank you.
What is today, Cedric Simpson?
Pardon?
What is today, Cedric Simpson?
Today is the 23rd.
Okay, Miss Lee, I'm sorry that I'm executing your husband.
You're executing what?
Miss Lee's husband, who is Adolph Mack. I'm giving him the electric chair. And I'm suing him for everything he owns. He's JP Chase Morgan. He owns Chase Bank. I want Chase Bank. He's Hitler.
Okay. All right.
I'm suing for Chase Bank and giving JP Morgan Chase, who is Adolph Mack, the electric chair.
Okay,
if
thank
Elon
you.
Musk works with me.
Okay, so here's what I'm gonna do.
And Donald Trump.
I don't know that we'll be
She had court yesterday, so, but
Oh,
she's here.
nope, we didn't have her yesterday. We just had her for today.
Okay.
So we're all good. All right. We will go on the record in the matter 25 GF 260, group file of Rita Wenzel. Appearances are, we have the state appearing in person through District Attorney Kevin Schmidt. We have Ms. Rita Wenzel appearing by video conferencing in custody in Burnett County Jail. This is Ms. Wenzel's request for a bond modification review hearing. The court has received your request, Ms. Wenzel. In your request, I believe you sent two. You're asking for a bail reduction because you take care of your sick mother and your handicapped sister and things like that. Is there anything else that you would like to tell the court in your request for a bond reduction?
Well, I do take care of my mom. I'm usually there from, between 7 and 9 a.m. until sometimes 7 at night. I prepare her meals. I shower her. I cook 3 meals a day. I'm there. A lot of my time is spent there. And then after I'm done there, then 3 nights a week, I go take care of my handicapped sister, which I give her a shower. And I do all my mom's med box, my father's med box, and I take care of my sister. So, I'm always, I work for my mother through IRIS, through the ADRC, aging and develop, the ADRC.
Yep, so you get paid to take care of your mother. Do you get paid to take care of your sister?
No, I do not. I was in the process of doing that. My background check hasn't cleared yet, but I've been taking care of her for 3 years. So she's really obese and she's got Turner syndrome. She's got a lot of health problems. She just currently had a heart attack and So my mom had open heart surgery and then after that she had a heart attack. My dad broke his back, so I was taking care of him too. So I've had a lot going on with my family in the last couple of years.
All right. So you're essentially asking for the court to provide leniency so that you can take care of your needing family members.
Yes, please.
Mr. Schmidt, argument, please.
I think bond should remain the same. Ms. Wenzel's charged with something very serious. Essentially, the allegations is that police did a controlled buy with her. One of the things the court should consider is the strength of evidence in a case, because the higher the strength of evidence, the higher the certainty of conviction, and given the potential penalty of possession or just straight up delivery on a controlled buy is quite a bit of prison. Ms. Wenzel would have a great deal of reason to leave. The main piece of evidence I'm talking about that's very strong is the CI in this case actually used a video camera. So I watched it yesterday. It's clearly Ms. Wenzel. You can see the methamphetamine in her hand that she gives the CI. It's a very strong piece of evidence. I'm also concerned she's saying that she is providing a lot of care for people who need care. She told Deputy Mangan that she does a line of meth a day, that she snorts. I think she has severe addiction issues that would maybe imperil people she's in charge of taking care of. I think the cash bond has to remain high because there's too high a risk that she would run.
All right, thank you, Mr. Schmidt and Ms. Wenzel. I do have the information that has been provided by the state here today with regards to information and evidence that he has reviewed, which is permissible and allowed to be argued in a bail modification hearing or in any bail hearing. I also have the probable cause statement, which does clearly state that there was a controlled buy on or around September 19th, 2025. And that, and it was a witness to have been a controlled buy in which you, Ms. Wenzel, are alleged to have sold methamphetamine to a confidential informant for $100. I didn't know about the video recording of it, but I just heard that through Mr. Schmidt right now. This is a very serious matter. You are being charged with manufacturing and delivering methamphetamine greater than 1 or 3, but less than 10 grams. And so this is a very serious allegation. Although the court does understand your desire to continue to provide services to your needing mother and needing sister, you are getting paid to do that for your mother, and you are in the process of trying to go through a background check so that you can get paid to take care of your sister as well. And there are concerns or there could be concerns if you are in fact a substance abuse user to be taking care of needing individuals, as well as the fact that you would be getting paid by the state to do so if you are under the influence of an illegal substance. So there are multiple layers here. So at this time, the court is going to deny the bond modification request, and it's going to remain at the $10,000 cash. We do have a next court date. I believe we should have a next court date, November 5th. So you did do an application, you completed an application for a court-appointed attorney, and the court did review that application, and you would need to have someone on your behalf, or if you have the ability to do so while incarcerated, there needs to be a deposit of $750 before the court can appoint an attorney to you. So please go ahead and try and figure that out before November 5th. I'm not sure why you don't qualify for a public defender. It could be because you own property, but if it has anything to do with your income while you are incarcerated, you do not have an income, so that could change your situation. So you could reapply. Do you own property? Is that why you're being told you do not qualify?
I have a house, yes, 648 North Nelson.
648 North Nelson.
Yes.
And so you own that house. Do you have any equity in that house?
What's that? I don't understand what that means.
If you have a mortgage on your house, let's say you have a mortgage for $50,000, but your house could be sold for $100,000, that means that you have $50,000 in equity.
No,
and you didn't provide me any of that information, so I don't know any of that information. What is the mortgage on your home?
I don't have a mortgage on my home.
Oh, so you do have equity. You have a lot of equity. You could sell it for $50,000 today, and you could have access to $50,000 cash. That's what equity is.
Oh, okay. I'm sorry.
So if you don't have a mortgage, that means you are fully, you have a full equity in whatever you could sell your home for. I'm not sure what you could sell your home for, but I'm going to tell you, in this market, at the very least, you could probably sell it for $75,000. That's without me even looking at the home. But Burnett County property is going for a significantly hiked amount. It's hard to find property here. So you would have the ability, you could apply for a mortgage in your home, get an equity lien in your home, so that you could either retain your own private attorney if you wish to do that, or you would have the ability to come up with that $750 cash. But that's where we are. And so we'll see you on November 5th for your initial appearance, okay?
Thank you.
Good morning.
Good morning.
We will go on the record in the matter 25 CF 37, State of Wisconsin versus Jared Stewart. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Stewart appearing by video conferencing capability. He appears along with his two attorneys that appear by video, Eric Nelson and Zachary Graham. We're set today in this matter for an arraignment. Either Mr. Graham or Mr. Nelson, did either of you go over that criminal information with Mr. Stewart?
Thank you, Your Honor. We did receive a copy of the information. We did go over it with Mr. Stewart. We advised him of its rights. We'd waive a reading of either at this time.
All right. And so not guilty pleas will be entered on his behalf. He is entitled to a jury trial. He would be entitled to a speedy trial should he request one. I'm pulling up co-defendant's case. I don't know if it makes any difference if we have them on the same date and time for you, for Mr. Stewart or Ms. Stewart, but I do have a status conference set with Ms. Stewart and her counsel on December 8th at 10. And video conference is fine.
Okay, I did see that, Your Honor. That works for me. I think Mr. Nelson's conflicted, but I think that's okay.
All right, so December 8th at 10, video conference is fine. And then just give the court an update and we'll see where we're gonna go, okay?
Okay, thank you.
All right, thank you. We are adjourned.
I'll be back with our next one.
All right. We will go on the record in the matters 25 CF 08, 25 CF 73, State of Wisconsin versus Jonathan Oyat. The state appears through District Attorney Kevin Schmidt in person. Mr. Oyat appears in person in custody with counsel Joseph Rosenthal by video conferencing. We're set today for a plea and sentencing hearing. Before we begin, Mr. Oyat, your attorney's appearing by video on that screen to your left. Are you okay with him appearing by video?
Yes, Your Honor.
Do you understand you would have the right to say, you know what, Judge, I want him to be here with me? You understand that?
Yes, Your Honor.
If you have any questions or concerns and you need to speak with him, let me know. And then I will have the correctional officer, CO, take you upstairs and put you in our Zoom room, okay?
Okay.
I need to check one thing with 25 CF 73. I need to make sure that we went through everything and it doesn't appear like we've had a preliminary hearing in 25 CF 73 because Mr. Oyat failed to appear. And I believe he's pleading guilty to one of those charges, correct?
Yes, Your Honor.
And so have you talked with him about what it is to waive a preliminary hearing?
I have, Your Honor. I discussed with him his rights. We did review the facts in the complaint and the burden that the state would have to meet at a preliminary hearing, and he would be willing to waive his right to a preliminary hearing.
All right, and that's true, Mr. Oyat?
Yes, Your Honor.
So you understand what it is to have a preliminary hearing in that the state has the burden to prove a felony was probably committed and probably committed by you?
Yes, Your Honor.
And do you understand at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses or call witnesses to testify for you? You would be able to testify if you wish. He would also be able to produce evidence on your behalf or possibly discover things about the case, which could include defenses, but you're giving up those rights today?
Yes, Your Honor.
Do you understand at a preliminary hearing, if the state does not meet its burden, I could amend the felonies to misdemeanors or dismiss them altogether, but you're giving up that right today?
Yes, Your Honor.
Do you understand as a result of waiving the right to a preliminary hearing, this matter could proceed further to other hearings, which could be a trial? You understand that?
Yes, Your Honor.
Do you understand that once you give up the right, it's forever and you cannot get it back?
Yes.
Has anyone made any threats or any promises outside of the plea agreement for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently and voluntarily?
Yes.
I find that you're competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I find probable cause and find the matter over. Information, Mr. Schmidt?
I filed the information. It mirrors the criminal complaint.
All right, so he understands charges, maximum penalties, waives formal reading. Is that all correct, Mr. Rosenthal?
Yes, Your Honor.
And not guilty pleas will be entered on your behalf as it relates to all counts. However, we are currently here for a plea and sentencing hearing. So Mr. Rosenthal, can you please recite the agreement for the record?
Yes, Your Honor. On 25 CF 8, my client would be entering a guilty plea to possession of methamphetamine, count 1. Count 2 would be dismissed and read in. On 25 CF 73, Mr. Oyat would plead to count 1, attempting to flee. Remaining counts would be dismissed and read in. Parties are largely in agreement. We would be recommending a withheld sentence with 74 days of jail, some credit for 74 times served. The one point of disagreement would be as to length of probation, but otherwise, parties are in agreement.
Are you hearing it? It's kind of muffly and weird. I heard everything you said, but it's just coming through as muffly.
I can try to speak up, Your Honor, if that's would be helpful. I don't know. This computer's relatively new. It's worked for me in the past, but I don't know if that's the issue.
I mean, it's fine for me. I can hear you and understand. And court reporter says it's fine for her too. So we're good to go. All right. So you're just arguing on length of probation. Otherwise, everything else is in agreement, correct?
Yes, Your Honor.
Mr. Schmidt, that's correct?
Yes.
I do have in front of me 2 plea questionnaire waiver of rights forms that have been filed in the cases here. Mr. Oyat, did you go over those documents with your attorney?
Yes, Your Honor.
Did he essentially go over them word for word?
Yes.
And you understand everything on there completely?
Yes.
And everything is accurate and correct?
Yes.
And is that your signature on the second page of both of those documents?
Yes, it is, Your Honor.
So you're pleading guilty to 1 count of possession of methamphetamine and 1 count of fleeing and eluding an officer. That's correct.
Yes.
You're 36 years old. You do not have a high school diploma or equivalent, but you can read, write, you understand the English language.
Yes, Your Honor. I'm 46.
You're 46.
Yes.
All right. So you're 46, not 36. So that's an error, but we're correcting that. All right. And did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt as to both of those charges?
Yes.
Did he go over the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights. Those rights are on the first page of both of those plea questionnaires. Did your attorney thoroughly go over those rights with you?
Yes, Your Honor.
Do you understand them completely?
Yes.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you need me to go over those rights with you in any more detail?
No, Your Honor.
You understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes.
Do you understand that you're pleading guilty to felonies? As such, you will no longer be able to use or possess a firearm for life.
Yes.
You will no longer be able to vote in any election until your civil rights are restored.
Yes.
You understand that the state would have to prove on or around January 4th, 2025, in case number 25 CF08, that you possessed a substance. The substance was a controlled substance, methamphetamine, and you knew or believed that substance was a controlled substance, methamphetamine. Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 3.5 years or both?
Yes.
Do you understand that with 25 CF 73, the state would have to prove on or around May 13th, 2025, that you operated a motor vehicle on a highway after having received a visual or audible signal from a traffic officer, a federal law enforcement officer, or a marked or unmarked police vehicle that you knew or reasonably should have known was being operated by a law enforcement officer, and you did knowingly flee or attempt to elude that officer by increasing the speed of your vehicle in an attempt to flee. Do you understand what the state would need to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 6 years or both?
Yes, Your Honor.
Do you understand that there is a recommendation to the court to place you on probation with the ability for each side to argue that length of probation with a withheld sentence? Do you understand I'm not bound to follow any recommendation?
Yes, Your Honor.
I could sentence you here today to those maximum possible penalties if I thought it was warranted. Do you understand that?
Yes.
Do you still wish to proceed and enter guilty pleas?
Yes, Your Honor.
Did you go over those criminal complaints with your attorney?
Yes.
And in particular, the sections where it basically says what happened those days and why you were charged with the crimes?
Yes.
For the most part, are those facts accurate?
Yes.
And I do understand that in your attempt to flee or elude an officer, in that fact pattern, you indicated that the brakes were not working correctly and that you were not attempting to flee and elude an officer. But are you stating here today, based upon the agreement reached, that you are in fact guilty of that charge?
Yes, Your Honor.
And with regards to the possession of methamphetamine, are you guilty of that charge?
Yes.
Mr. Rosenthal, may the court use the probable cause sections in the criminal complaints to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has
Yes.
he answered all of your questions?
Yes.
Has he looked at these matters thoroughly?
Yes. I
Did he
believe so.
discuss with you any defenses or a lack of defenses with you?
Yes.
Did he discuss the evidence in both cases with you?
Yes.
Now, did you discuss your statement that you made in the attempting to flee or elude, that you made to the officer, that you were not attempting to flee and elude, and that you stated that the brakes were not working?
Yes.
And based upon your discussions with your attorney, you're satisfied that he has done a good job?
Yes.
And again, you're pleading guilty to that charge because you're guilty of that charge?
Yes, Your Honor.
All right. Do you have any questions for the court or for your attorney before I proceed?
No, Your Honor.
As to count 1 in 25 CF 08, possession of methamphetamine, how do you wish to plead?
Guilty.
As to count 1 in 25 CF 73, flee or elude an officer, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 2 charges. The remaining charges in both of those cases will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you, Judge. I think the court needs to do a significant term of probation because Mr. Oyat has a pretty significant criminal history going back over 2 decades. It's connected to his substance abuse. In addition to substance abuse convictions, he has multiple convictions for either resisting or obstructing an officer or giving an officer a false name, 2 convictions for failing to report to jail. Today is his 4th conviction for fleeing an officer in a motor vehicle. He has violent convictions as well, as such as for substantial battery and aggravated robbery. I think the court has a lot of reason to want to make sure that he treats his substance abuse issues. Because of the prevalence of those convictions going back 2 decades, it shows it's been a hard problem that's been tried to be addressed for 2 decades. In fact, Mr. Oyat recently went to treatment and discharged against medical advice after being there for 63 days. Had he stayed there, he could have completed the program. They had sober living lined up for him. The discharge summary showed explicit concern about him maintaining sobriety after leaving against medical advice, as well as concerns about his anger emotions. I think 3 years is going to be the minimum we need to try to address what's been a prevalent issue, I assume, most of his life. He would obviously be a better historian than that for it. He has some incarceration right now, which leads into the time served aspect of that jail part of it. I think this might be a person who would be appropriate for conditions that include some conditional jail upon any positive test results, simply because of that prevalent history. And he should have conditions of not driving without a valid license. He has licensure offense convictions in the past as well. So that's what I would ask the court to do. Thank you.
All right, thank you. Mr. Rosenthal, before you provide your argument, and maybe this is a question for Mr. Oyat, is he still on extended supervision?
Go ahead, Johnny. If you.
No, I'm not, Your Honor.
And no probation?
No.
All right, thank you. You may argue, Mr. Rosenthal.
Thank you, Your Honor. I think my client is a good candidate for probation. He has successfully completed that in the past. I was looking at CCAP, I believe it's case number 18 CF 88. He was on probation there for 3 years with some prison time hanging over his head. From what I can tell, he did complete that successfully. I think that reflects well on his character. As far as the treatment, He was proactive about it. I mean, I think it's kind of a mixed bag. I do think he should be given some credit for that, Your Honor. He went voluntarily into the healing center. He was there from June 19th until August 5th for 63 days, and then was set to graduate the next day and did not go to the graduation ceremony, but and he was set to go to sober living. That is all accurate. What my client was indicating was that, or has indicated to me, is that he felt he had a solid foundation for sobriety. He just wanted to go home and be with his family. He was out in the community for a couple of weeks before being picked up on the warrant. He was staying sober for those 2 weeks. He's got over 4 months of sobriety right now, and granted, some of that is enforced while he's been in custody. But the 2 months of inpatient, I do think, does reflect well on his character, does show he's willing to deal with the longstanding AODA issues. As far as the conditional jail that the state mentioned, there were some negotiations about that. My position on that, Your Honor, is that, every case, just like every case is different, every person's journey in recovery is different. I don't think there should be a blanket number of days for a violation. I mean, every relapse is going to be different. I mean, it's one thing, I think, if he is, out doing well on supervision, maybe has a relapse, comes in and is honest with his agent about it and tests positive, versus, absconding for 6 months and then not being honest and testing positive. So, if the court were to do that, I could see perhaps borrowing like a concept from probation failure to support, where it's like a graduated type of conditional jail. Maybe 5 days on the first, 10 days on the second, graduated, 20, then 30. I don't think that every positive test should have like a blanket number just because of some of the factors that I mentioned. He has been struggling with AODA issues for most of his life, as his record would indicate. But again, he took some accountability here. He's pled today. He's taken responsibility. For those reasons, Your Honor, I mean, he's either going to figure it out or he's not. I think that the 2 years would be sufficient to see if he's going to be able to make those necessary lifestyle changes. Thank you.
All right, thank you. Mr. Oyat, first, before I ask if you want to provide a statement, what is it going to take to get your driver's license back?
Far as I know, I just have to do the Aurora AODA, and then I don't know how long they'll be suspended because of the fleeing, but that's it, I guess. It's just that, and I can get them because I've never had them. So.
Well, the court may suspend your driving privileges, but the department shall revoke your driving privileges for 6 months without fleeing. So the Department of Transportation, they will revoke you for 6 months, but after that, you should be able to get your driver's license. And I'm not certain if through that revocation period, if you do your AODA and other assessment, that you may be able to get an occupational or something like that. That could be something that you should look into.
Cool. Yeah.
All right. Any other statement, anything you want to let me know, Mr. Oyat? You don't have to, but it is your only opportunity.
No, Your Honor.
Mr. Oyat, you've been here before. I think quite a few of those convictions happened in front of this court. So you understand what the court has to look at. You understand I have to look at the nature and the gravity. How serious is this matter? And then I look at you, Mr. Oyat, and not only do I look at your criminal history, I look at your character. I look at things that you have done on bail, granted bail. I have to look at your intelligence. I have to look at your mental health. I have to look at all of these kinds of things. And then I also have to look at the third factor, needing to protect the community, and if there are any specific victims or the community as a whole as a victim here, and what I need to do. And that could include rehabilitative measures such as probation and other services that you can do and you can be a part of. You're 46 years old. You're at that point where you're old enough to not deal with the things that you're doing. You're at an age where I know your children are grown now. And I've known both of your children. They've come in front of me for various things here and there. I've told you this before, that you are a significant role model to your kids. And what you do and how you do it is teaching them how to be. And I can tell both of your kids have a really good, kind heart and soul, and they really shouldn't be sitting in that chair in orange ever. And if you want to see that stop, you're the one who's going to have to get up, take control of your life, and do things better. Because someday you may be a grandparent, or are you?
Yeah, I am.
Yeah, you are. I think your daughter.
Yep.
So you also have those little ones that are watching you and learning from you. And I know that you care about your family. And I want to see you do better. I want to see you do better. It was disheartening when you left from treatment, especially because you had, I don't want to say begged the court, but you were very excited, looking forward to going to treatment and finding sobriety and finding the steps and the resources and the things that treatment was going to provide you and to teach you so that you can do it on your own and you can better yourself. I would agree that, I can't remember if it was Mr. Schmidt or your attorney said it too, but I don't want to say you have an anger problem or an anger issue, but you do need to learn how to take a breath and respond instead of just react. And I think that your past and all of the charges, which go back to that substantial battery one, which that was a very serious case, you were responding, or you were reacting to situations and reacting with force and without taking the time to actually think and to see how your actions are going to affect you and affect your kids and affect your grandkids. I don't think that sitting in that chair in orange is the person you want to be, Mr. Oyat.
No.
I've heard you before, and I believed you, and I do believe you that you want to change. But you're the only one who can do that, Mr. Oyat. You. And as a grandparent, you should be wanting to sit down and play blocks or read books or, take walks or do those types of things instead of sitting here and watching them grow while you're kind of wasting time behind bars. I don't think you want that, and your family certainly does not want that. So if we're looking at the possession of methamphetamine, it's serious because it's methamphetamine, and we have an epidemic here. We have an epidemic, and I don't know how to control that. I don't know how to stop that. But only you can take control of yourself, your situation, your life, and only you can stop that. Only you can stop that. And we have the fleeing and the eluding. Yeah, I don't know if I believe that your brakes were broken. Were they? For real? And be honest. No. And you're shaking your head. No, they weren't. That was just your excuse because you went up to 90 miles an hour in a 55. And that was that criminal thinking, or that was that bad thinking of, I don't want to get stopped. I can't get stopped. I'm going to get in trouble. I'm just going to escalate the situation and react and drive faster. When you know, Mr. Oyat, you know you're going to get caught. If not caught that night, they knew who you were. you would get an arrest warrant and you'd be sitting there probably with a whole lot more heat on you than after they pulled you over. You understand that?
Yes.
You've had some time to sit in jail. You've had some time to think. And I'm hoping that that's given you an opportunity to come up with a plan and to come up with things that you want to do or how you want to do them instead of continuing to sit in that chair. That's doing no one good.
Since I successfully completed parenting class. I got certificates back there that I've received since I've been here.
What did you learn in those classes?
How to be a father.
Also, I'm sure how to be a grandfather too,
No.
because it's kind of the same. It's just different. And did that give you any different perspective?
Yeah.
What?
That, just like you said, I'm tired of being here, I don't want this life no more.
I don't want you to have that life anymore because I've seen you and I've seen that you can be soft and you can be caring and you can do positive things. I've seen that side of you, Mr. Oyat. I don't like this side of you. I don't like the side that goes 90 miles an hour to try and get rid of the police. I don't like the side of you that is quick to anger and quick to get hot. But I don't think you like that either. I'm going to put you on probation. I'm not sending you to prison right now, and I'm not going to make you sit any more time in jail. I think you've had time to sit. And I think that the extra time that you sat, since I couldn't fit you in earlier, we tried to fit you in, but it had only been 2 to 3 days earlier since my calendar cleared. So it wouldn't have made a big difference. But you've had time to sit and to think. And I think you realize that, I'm hoping you've realized that you should have finished treatment. You should continue to go to treatment if you have that ability again. And you should take it more to heart and more seriously. You have to change the places you are. You have to change the things you're around. You have to change the people you're around to be able to change you. And the changes that you make in you will trickle down to your kids and definitely trickle down to your grandkids. Let's stop this generational cycle of having Oyats in that chair. It starts with you. I'm not trying to make you feel bad, but I'm just telling you the truth. It starts with you. And you're so strong in some ways. Put that strength on this other side. You want that?
Yes, I do.
I understand the argument of 3 years of probation. Quite honestly, I'm going to tell you, and I'm going to be blunt. I don't think it would matter if I put you on 1 year of probation, 2 years of probation, or 3 years of probation. If you're not going to heed this discussion, if you're not going to take control of your life and your situation, you're going to do it sooner rather than later. That's just what this job has taught me. And I'm not saying you as in just you as in any person who's on probation. Either you're going to figure it out and you're going to want it really bad and you're going to follow that and do that, or you're not, and you're just going to go back into your old ways sooner rather than later. I'm going to place you on probation for a period of 2 years of probation. I think that's a good compromise between an argument with probation. I'm gonna give you food for thought with this sentence. I'm not doing withheld because your food for thought is going to be, this is going to be a prison sentence imposed in state. I know you've been there, Mr. Oyat, and I know you can do it and I know you can handle it. You've done it before. I don't want you to want it or not care anymore. I want you to go on probation. I want you to do the things you need to do. And I want this imposed in state prison to be something that scares you or something you really don't want to do instead of, I can do it. I don't want to see that attitude. I want to see the attitude of, I'm going to do whatever it takes so I don't have to go back in the positive way and making positive changes. Okay?
Thank you.
So with regards to the sentence, I'm going to do an imposed and stayed 1.5 years of initial confinement with 2 years of extended supervision. All right? But it's imposed and stayed. You're given this chance, Mr. Oyat. You're given the silver platter to do what you want to do with your life and to make the changes you want to make. Again, change your places, change the things, and change the people. And the people that you don't want to change or you can't change, be positive influences, be a positive influence to those people to change those people. Well, on probation.
What count?
Oh, sorry. That's for both counts. Both counts, same thing, concurrent. Because this is serious, but it's not that serious to be a max on both of them to be consecutive. Again, this is so you can think and you can make the choice. You're going to make the choice, Mr. Oyat. Well, on probation, I'm going to order the AODA OWI assessment. I'm saying both because I want you to be able to get, it's kind of an OWI assessment that you're going to do anyway. So then you can check that off your probation list. You can check that off getting your driver's license. Okay.
Okay.
I'm going to order that you get your driver's license. All right. I'm going to order that you go through an anger management program, and you can do it with Dave Hatch here, Restorative Justice. Or if you want to do it somewhere else that DOC suggests, you can do that. But I don't know if you know Dave Hatch.
Yeah.
He does really good programs. I'm going to order, I said you get your driver's license, you do the assessment, anger management, that you do like a thinking for a change or breaking barriers type of program. And your Department of Corrections agents, they'll be able to do that for you or tell you which one to do. I'm going to order that you have gainful employment. Doesn't have to be full-time employment. It has to be employment. It has to be something to get you to do a positive thing. It just has to be enough for you to have money to pay your bills, have money to buy presents for your grandkids and your kids, and to do that kind of thing. Again, it doesn't have to be full-time, but gainful. Testing, regular testing of your blood, breath, urine, hair follicle, fingernails, of illegal substances. So no use or possession of any illegal substances, no medications without a prescription, and no drug paraphernalia. It's going to be absolute sobriety. DOC is not going to let you have alcohol anyway either. So I'm just going to say the absolute sobriety. I understand the state's argument with regards to ordering that if you test positive, have a certain amount of conditional jail with each positive test. I'm not going to do that here. I would in other cases. And I would here, except for the fact that I want you to want it. And it usually turns out that if you are using illegal substances, you don't just do that, you again react and you do other things. I want you to want it, and I want you to seek the treatment, and I want you to be sober. And I want you to be honest with your agent. So if you haven't, I want you to understand that I don't want you to know, well, if I'm honest, I'm going to have to sit 10 days or I'm going to have to sit 20 days. I want you to be honest with your agent if you've had use, and to address it appropriately that way, because this is the way you make the positive steps and you gain control of your life. Because number one is honesty. Honesty, first and foremost, you have to be honest with yourself. Then you have to be honest with your agent. And then you find something some service or something that you can do to help combat that use. Okay? I'm ordering your DNA. The jail will make sure that they get that. I'm going to order $443 in fines and fees for the fleeing and the eluding. Or no, sorry, $518 in fines and fees for the fleeing and eluding, $250 DNA surcharge for the possession of methamphetamine. I'm waiving the rest of the court costs and fees for that. I don't know if you owe anything else for any other cases. Do you know if you owe anything else?
Not that I know of, Your Honor. I don't.
I'm going to order at minimum $100 per month to be paid towards your fines and fees. And I'm going to have you pay them here at the clerk's office, not at DOC, because I'm going to monitor and make sure that you're paying it. Because I could enter a civil judgment if you don't. I could issue a warrant and have you sit up to 6 months in jail if you don't. And that's another accountability factor, is paying your fines and fees, being accountable for that. If you can't afford it, you can't find a job, you can't do something like that, then I need you to write me a letter and tell me why, and I'll see if I need a hearing to address it. Okay?
Okay.
Have you thought of the Ruth House? Or anything like that, going there and helping them help you get a job? And
Yeah, been talking to Pastor Jack. So, after I leave here today or whatever, I got to call him. So
you have 20 days to appeal, and I'm glad to hear that. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. 74 days of jail credit. You must report to probation immediately. So when you're done doing all things with the jail, you go to probation, you get it all set up. Are you still at Sandpoint Road?
yes,
Telephone is in 5642.
yes.
Do you have a cell?
No, I don't.
Okay. If you do have a cell phone number, if you do get a cell phone, please give it to probation when you get it and give it to the clerk's office too.
Okay.
All right. Oh, thank you. No, this is a felony, no use or possession of firearm for life, no voting in any election until your civil rights are restored. Okay?
Okay.
Mr. Schmidt, what am I missing?
Maybe I missed it, but did the court say he's eligible for ERP if he's revoked?
I did not say that, but if you are revoked, you would be eligible for the substance abuse programming in prison. Okay? I want to see you seek that outside of prison. I'd like to see you go back to treatment. I'd like to see you graduate and go forward. Mr. Rosenthal, anything I'm missing?
No, Your Honor. Thank you.
All right. Then we are adjourned. All right. Thank you.
To the campus. Even though Huron Township.
That is correct, but you're only. Friend on scene said that he was the passenger.
I'm gonna give you some roles. We've established already, but August 31st of last year, right?
Yes, sir.
That's now, right?
Yes, sir.
Okay. I'm gonna give you some times, and you may not specifically recall the hour. according to this run sheet, it says, the call came in at 22:49.
10:49 PM.
Do that sound about right?
I believe it was in the evening, yes, it was dark outside.
Yeah. And, according to this sheet, you guys were dispatched a mere second later. Said you were en route at 10:50. It said you arrived on the scene at 10:54. Were you guys that close to the scene where you arrived for?
That is approximately less than 5 miles from my home base station at that time, yes, sir.
And I imagine this is, they travel at a hybrid speed, so.
Yes, sir.
It says here that, again, you arrived at 10:54, patient conference. Now, you mentioned earlier that, I was already out of the car.
Yes, sir.
You were,
Yes, sir.
was there another good?
Yes, sir.
Did he appear to be intoxicated or having?
I could not recall.
It says you guys left the scene at 11:32. So, almost 40 minutes later. So you were on the scene about 40 minutes.
We were waiting for the other police department to show up due to the jurisdiction guidelines. That's something that is controlled by the police officers. If it was something that was emergently transported, then we do have a say, but yes, it does take some time.
During 40 minutes, I'm mad. Breaking this is small. Well, hold on, it has here, this time was saying approximately 30 minutes. Assigned to destination was 63 minutes, according to this run sheet. Would you say that's like some type of, mistake, or how far was, Courtroom Health, from the scene of the accident?
I would say probably less than 20 minutes away from where the accident scene was.
Is there any, reason why I say time to destination 63?
It could possibly be that was from the time that we arrived on scene with the 40 minutes and then the 20 minutes transport. I'm not exactly sure without the run in front of me, how it looks on their end.
Yeah, that's what it said. Then it says the total time run, 78 minutes.
So that would be from the call dispatch time to when the time that the call is closed, after we clear the hospital.
Well, it seems as though I heard you say that, you work for, Elon,
Yeah, Valley Ambulance.
Right.
Yes, sir.
Okay, so you would say that you had extensive, professionalism when it comes to doing your job.
Yes, sir.
And you're able to, observe things and then later on, describe exactly what you observed.
Yes, sir.
Mr. Greco, any redirect?
Nothing further.
All right, can we send Ms. Stig back to wherever she'd rather be?
Yes.
Watch your step on the way out.
Thank you, sir.
Thank you for your time.
Take a recess.
Sure, you do a nice job on the stand. Yeah.
I appreciate it.
Mr. Davis could probably use a stretch anyhow. Yes. All right. So, yeah, well, Jamie will take, and I should if you have personal stuff with you, you can take it with you. We're going to take you back into the jury room where there's a bathroom and the refrigerator with better be waters in there.
Yeah,
So you can take your stuff back there, leave it there, leave it here. This room for the extent of the trial will never be unmanned. One of the security guys will be in here or outside the door so nobody's in here. So take your stuff, leave your stuff. When you're all ready to come back in, let us know and I'll make sure everybody else is ready. So we're in recess. Mr. Stokes, take a break. Oh, okay, okay.
Oh, yeah, yeah.
Okay, door's closed.
Yeah, so the next witness that I was planning to call, I subpoenaed here is Cody West, who was her partner, who was in the back with Mr. I don't really need her at this point.
Okay.
So I wanted that, unless you want the other EMS guy, he's gonna probably testify the same.
You want to call him?
Well, I'll call.
Okay,
Yeah, but on this case,
okay.
please hear, that's fine.
Let's do this. I'm gonna go with, if you two are all right with it, instead of bringing them out here so I can talk to them on the record. I just want to duck my head in there and say, look, you guys talk about whether or not you want to take a lunch break or you just want to see how things go before you decide on if you want a lunch break. Because I always let the jury decide whether or not we break and when we break. All right. So if they just want to say, hey, let's just bull through and keep working, that's what we're going to do. Are you okay with me having that little conversation with them?
You're saying you might not be able to. Employed?
I am, yes.
And where are you currently employed?
Here on Valley Ambulance,
And how long have you been employed here?
just short of a decade.
Okay, just short of 10 years. And what is your position of employment?
I am a senior paramedic.
Okay. And hold any particular licenses or certifications?
Several. I have a paramedic license and then several specific medical certifications.
Okay. And in your position as a senior paramedic with Huron Tepe ambulance, you have the opportunity to go to and handle automobile accident scenes.
Pretty frequently.
It's kind of part of the big part of the job, correct?
Correct.
Okay. Do you recall if you were working during the evening of August 31st, 2024?
I have reports from that time, so
Okay, you were subpoenaed up here, so you looked at your reports. Okay, so you refresh your recollection a bit on a visual of what occurred that night?
to some degree, yes.
Okay. Do you recall responding to an automobile accident scene that evening at the Tepe corner of Pennsylvania Road and?
I do.
Okay. What do you recall about showing up that evening?
I recall that when we pulled up, there was a vehicle in the ditch that had apparently gone through the Tepe. Went straight through and was down in the ditch on the far side.
Okay. And do you recall encountering an individual by the name of Carrie Stokes?
I don't, yes, I do remember.
Okay. Do you recall how you would, let me ask you this. Do you see Carrie Stokes in the courtroom today?
I'm sitting over there.
Okay.
You don't visually.
You don't recall visually. Fair enough. But you recall an individual. Do you recall an African American individual?
Yes.
Okay, but you're saying you might not be able to spot him.
If you were in a line, I probably would not be able to.
Okay, because it's over a year ago. Okay, all right, got it. But in looking at your records, you were at least responding to a scene of a person by the name of Carrie Stokes.
Correct.
Oh. All right. Do you recall how you first encountered that individual?
Per my report, he had already gotten out of the vehicle when we arrived and was just standing around on the scene with Huron Police Department when we initially pulled.
Okay. And do you recall any interaction you had with Mr. Stokes that evening?
I do recall some.
Okay, what do you recall about your interaction with Mr. Stokes?
Most of my recollection is after we were in the ambulance, belligerent and uncooperative with us.
Okay, how did you become belligerent and uncooperative?
It became verbally aggressive. He was pulling our equipment off and throwing it in the ambulance. He wound up standing up and urinating inside the ambulance on some of our equipment. So,
In your professional life, have you had had encounters with individuals that are intoxicated? Very. Okay. And what are some of the symptoms of a person who's under the influence of alcohol?
glassy eyes, impaired gait and balance, slurred speech, poor impulse control.
Did Mr. Stokes, make any observations with regard to Mr. Stokes and his intoxication as far as your observation there?
He was displaying most of those symptoms, yes.
And you described his behavior, of course, and already against Indiana. There's been prior testimony that he had to be restrained. That's okay. And once he was restrained, what did you guys do?
At that point, we remained on scene until Romulus Police Department was set with their initial part of their investigation, and then we transported him to Corwell Taylor.
Okay, so the old Heritage Hospital or what else on Telegraph Road team, right? And then once you transport him there, does that conclude your involvement with Mr. Stokes in this matter?
Yeah, once we transported him there and I transferred care to the nurse, so that report, that was the end of my contact.
Thank you. I have no further questions.
Mr. Stokes, do you have any questions for Mr. Holmquist?
Yes, I think that you're following partner, all of you from my very states.
I appreciate it.
I asked your phone partner, if she was aware of we made the call to, Huron Valley, said it's, she said she couldn't be called to you.
No, I do not. A lot of the time, that's not information that we wind up with somebody on scene specifically tells us.
So you don't know who, you don't know time. Well, if I had one, she did.
The time that the call was made would have been documented in the report, but I don't.
It says on the shelf. It's here. We won't take you back, to that night you said when you arrived on the scene. I was, outside of the vehicle talking to, Huron Township Police Department.
That is my recollection. And
okay. Was there anyone else there that seen besides you guys, the Huron Township Police Department and myself?
The Huron Township Fire Department also responded with us. So it would have been us with the ambulance, the fire department, Huron Police Department, and yourself. I do not remember anyone else other than those 4 sets of people.
Well, in the primary rooms, they stated that there was nothing should be named Jason Ford. Of course, you would know his name, but you ain't seen other African out there. So.
I don't recall there being another individual that the car crash scene with you.
Well, now, you, as well as your former partner, gave testimony that I was appeared to be and intoxicated?
Your appearance was consistent with intoxication. I can't officially diagnose whether that's what was causing it, but the symptoms were consistent.
So, you just wouldn't shoot for it just was consistent.
Correct. I don't have the ability to feel to test your blood alcohol. That's the place to do.
Okay. Well, in this case, the prosecution is alleging that I was full super Trump. What would you, as a paramedic, be classified as?
To my knowledge, that's a specific like legal term. That's not something medically.
Well, how intoxicated would you say? How impaired would you say a person is if he has that high?
It depends, varies. It would depend on the individual and their usual like tolerance to alcohol. That's a hard question to answer.
That makes sense. You got there. Someone with that level of intoxication, in your medical opinion, how long would you say it takes to sober up? So I felt that.
Jack, for lack of expertise, I think this is, unless you can answer the question, I don't know if we played a foundation for whether this one.
Do you understand the question?
Yeah.
You feel qualified to answer it?
Probably not.
Okay,
I will.
go ahead. Next question. Mr. Greco?
Nothing further for this witness.
Mr. Holmquist, you are free to leave. Watch your step on my ramp. Thank you for your time. Could you two approach?
We'll agree with this. The forum's house, I'll be the funny bullshit. Because it's the only please.
Close. If you recall being called at the scene of an accident.
Sir,
Okay, what do you recall about that?
I recall it was on the west side of the road, Huron Township ambulance, as well as the police department were on scene. And it was in our jurisdiction, so they wanted us to conduct the investigation. For the ambulance, I believe they stated the male appeared to be intoxicated. And that was the call once we got.
Okay, so you guys come to the scene to do an investigation, correct?
Correct.
Okay, this was a single vehicle accident?
Yes.
Okay. Do you recall what kind of vehicle it was?
A blue, Chevy Monte Carlo.
Okay. And did you encounter a person by the name of Carrie Stokes?
Yes, sir.
Okay. And who was Carrie Stokes that evening?
Kerry Stokes was the male in the back of the ambulance who was attempted to be interviewed, who appeared to be very intoxicated.
Okay. Is Mr. Stokes in the courtroom today?
This is,
Are you able to identify?
and he is the male directly behind you.
Yes.
Noted.
Thank you. What kind of interaction did you have with Mr. Stokes, if any, at the scene?
So he was already in the back of the ambulance at the time of our arrival, but coming to speak with him, his speech was very almost, you couldn't even understand the words he was trying to say.
Okay, so difficult to interview.
Very difficult.
Okay.
Yes, sir.
And let me ask you this, as part of your job, have you had the opportunity to encounter individuals that are intoxicated? So, okay. And what type of signs of intoxication do people that are intoxicated exhibit?
Slurred speech, glossy eyes, very unsteady on their feet.
Now, Mr. Stokes was not on his feet when you got there, but were there signs and symptoms of being intoxicated?
Yes, sir. Slurred speech and odor of alcohol emanating from this person.
Okay. All right, so when you get to the scene, what is it that you do? Sounds like you had some interaction with Mr. Stokes, the ambulance, what else?
We also interviewed the passenger of the vehicle.
Okay, so there was another individual there?
Yes, sir.
Okay, looking at the report, looks like the person's name was Jason Porter?
Yes, sir.
Okay, so did you make a determination that evening as to who was the driver of the vehicle?
Yes, sir. Spoke to Jason Porter, stated he was the passenger. He was riding inside the vehicle with Mr. Stokes because Mr. Stokes told him he knew where he was going. That's why he was driving.
Officer Otter, I'm going to hand you what's been marked as People's Exhibit number 1. I ask you to take a moment to take a look at that. What is this exhibit?
This is a picture of the vehicle that ran off the roadway.
Okay. Do you know did you take this picture or did you know a part of it? You know.
I believe my partner took the picture.
Okay. Is this a picture of the defendant's Monte Carlo off the side of the road?
Yes, sir.
Okay. Does this photograph accurately depict the scene that evening with the vehicle off the side of the road?
Does.
Your Honor, move for admission of exhibit number 1.
Thank you. Mr. Stokes, any objection to that being admitted? Thank you. That'll come in as People's 1.
As part of your investigation, did you have an opportunity to go into the car?
Yes, sir.
All right. Would that be a routine part of the investigation when you're potentially making an arrest for drunk driving?
Yes, sir.
Okay. So what do you recall about going into the car?
In the vehicle, there was multiple bottles of Bud Light. Multiple bottles were actually cold to the touch, appeared to be possibly recently purchased or recently taken out of a fridge. Multiple open containers, as well as empty ones, and new ones as well.
Officer Otter, I'm going to hand you what's been marked as People's Exhibit number 2. And ask you to take a look at that. It's a series of photographs,
Just for the record, 4 pages.
4 pages.
Thank you.
These pictures. And what are these pictures of?
These pictures are of alcohol that was in the vehicle.
Okay.
You searching it?
Okay. Do these photographs, well, let's go. The first one looks like a photograph of like a Bud Light paste and some bottles strewn about.
Yes, sir.
Okay. The second picture, what is that?
Those would be two full bottles of Bud Light outside of the packaging they came in.
Okay. Does it look like they're sweating a little bit? Is that?
Yes.
Were they cold to the touch?
They were cold to the touch.
And what's the third picture?
Third picture is a six pack of Bud Light with bottles missing out of it.
Okay. And then the fourth picture?
Fourth picture is a picture of a open Bud Light in the back seat. Pocket of one of the seats, as well as multiple Bud Light bottles, including a six pack with bottles missing.
Okay. And now you indicated that one of the bottles is open. Which one?
The one in the pocket of the.
Oh, on the seat right here?
Yes.
Okay. Was there any alcohol in it?
I do not recall exactly.
Okay. Do you recall any open bottles that had alcohol in it?
I do not, but I'm also seeing empty one on the ground as well. There's an empty bottle.
Got it.
Bud Light on the ground.
Do these photographs accurately depict the inside of the defendant's vehicle that evening?
They do.
Your Honor, move for admission of Exhibit 2.
Any objection, Mr. Stokes? That'll come in as people's too. Thank you.
And at this time, officer, I'm going to play you a brief video just to make sure we've got.
He's gonna do an, share this one.
That should come up on that screen right in front of you folks. Should.
Okay.
You can share that image just on the screen. Click on share.
Okay.
Is it coming up?
So,
It's not coming up?
No, because
you see,
maybe let's turn.
Oh, it's just gonna come up there. Okay.
you can see the screen. Oh, okay, there. So, before I'm about to play this video, Officer Otter, does this look, what does this look like? What video does this look like?
It's like the dash cam to one of our patrol cars.
Okay. Now I'm gonna hit play and I'm gonna advance a little bit, so we don't have to see 1 minute of you guys drive. While looking at this video, does this look like Cannon Road?
It does look like Cannon Road. We're approaching the Huron Township vehicles that were already on scene.
You're approaching the intersection, the T-bone intersection, stop for a minute, of Pennsylvania Road and Cannon Road?
Yes, sir.
So Pennsylvania Road is to the left of the screen, correct?
Correct.
Heading west into Hannon Road, and you're approaching a stop sign at that corner, correct?
Correct.
Now, looking at this video, does this look like the dash cam video of the vehicle that you were in that evening?
That is correct.
That is the vehicle, okay. Now, I stopped it right here. What do we see on the screen here?
See suspect vehicle.
Okay, off to the side of the road as described?
Correct.
Okay, and then we see the ambulance to the left.
Yeah.
Correct. This is the scene that you showed up on, correct?
That's correct.
Now, does this video accurately depict what occurred that evening up to this point with the vehicle you encountered?
Yes.
Your Honor, with respect to this portion of the video, we move for admission of exhibit number 3.
Mr. Stokes, any objection?
I only object if that's the conclusion.
Well, that's all, that's the only portion he's attempting to get into evidence at this point. What we've seen so far is all he's trying to admit.
And the entire radio.
You can.
No, I have no objection to the entire video being played. It's just not, it's gonna be dash cam video of people walking around. So, and I don't think it's relevant, so I'm not planning on playing it. But Mr. Stokes, you're able, we'll play it if you want to play it as part of either your cross-examination or your case in chief.
Yeah, I won't ask you to stop it or anything. I just, you know,
How long is the video? from here till the end of the,
13, it's 13 minutes.
okay, have you watched this in its entirety?
Yeah, last year.
Okay, so I'm not going to play 13 minutes of nothing if that's all we're going to see. Okay, thank you.
So,
So any objections to admitting what we've seen, what we've watched? The portion that we've seen? Any objections? You're going to get a chance at that, but at this point, the question is, do you object to this little snippet? I don't know how long we got, 1 minute or whatever it is, of video being admitted as People's number 3 exhibit.
Well, you know why I'm objecting, because I may want to use a portion of during girls.
Well, A, you can certainly refer to what's admitted as evidence, just like one of these documents you could do. And if you want to replay what's already admitted, we can replay it. All right, so no objection? Okay, so that portion of the video that we've already seen is admitted as People's number 3.
Absolutely, Your Honor. And I wanted to do this just so the jury got a good visual of the scene day. That's it, for the purpose of relevance with respect to it.
Go ahead.
Officer Otter, were you able to provide or perform any field sobriety tests on Mr. Stokes that evening?
No, sir, he refused.
And was he kind of strapped down on the gurney by the time you got there?
Yes.
Or at that point in time, once you attempt to interview Mr. Stokes, can't do field sobriety tests, he's already in the ambulance, and you already testified that you went over to the car to take a look at it. What's the next thing that happens at the scene as far as what do you guys do?
So my partner was speaking to the passenger while I began to look in the vehicle. And we conduct an inventory search for the vehicle as well, besides just a suspicion of operating intoxicated. The vehicle needed to be impounded, so I was conducting my inventory search when I located all the open alcohol as well as the closed alcohol that was in there.
Okay. And then, once you do your investigation, do the inventory, we saw photographs of the beer bottles in the car. What's the next thing that happens with respect to the case, like procedurally, time-wise?
Time-wise, we read them their PI 177, which is their chemical test rights. They have the right to refuse or say, they submit to a test, so refuse. So we went back to the station and got a search warrant while he was being transported to Below Taylor.
Okay. So you're saying, in your testimony, the DI 177, that's the chemical test rights to consent to either a blood draw or an intoxicant, correct?
Yes.
Okay, you're saying that he refused.
Correct.
Okay. And then at that point in time, you're saying that he's then, because he concludes that scene, transported to Corwell Health Taylor.
Correct.
And what do you guys do with the vehicle?
We impound the vehicle. I believe it was towed by probe towing. And then we went back to the station to complete our search warrant.
Okay. And then once the search warrant is completed, what's the next thing that happens?
The next step is you make a copy so you can give it to the people at the hospital, so they have a copy of it. You go to the station you go to the hospital and you give it to the RN or whoever is able to perform the blood draw, provide them the search warrant, and they collect his blood.
Okay. And as far as presence during the blood draw or collection, would that be you or Officer Matheson?
It would have been Officer Matheson.
And then once the blood's drawn, we'll get into that with Mr. Matheson, other than, creating a report. Does that basically conclude your investigation for the evening?
Yes, sir.
Thank you. I have no further questions.
Mr. Stokes, questions for Officer Otter?
Yes.
You stated that you were called to the scene of the accident. Okay, so that and video shows you speaking, to the same, you stated that, upon your arrival, I was already.
That's correct.
I assume that you're unaware of who called me.
I'm unaware, that's correct.
Then, you said you're a partner, Madison. Were you guys traveling in different vehicles or?
We're in the same vehicle.
Yeah, we're in the same vehicle. Okay. Maybe that actually when she was basically your go-to.
I do not recall my exact actions, but I probably went over to passenger of the vehicle as well as when checked on you based on the statements from the officers on scene as well as the paramedics. As far as after talking to you,
Yes.
just went, did my search of the vehicle and gathered more information that I needed.
So you have dash cam video from your vehicle, which is clear. Were you wearing a body cam?
Was.
Do you have, body cam footage? Did you?
There's body cam footage from me, that's correct.
Okay. Do you have body cam footage of you, searching the vehicle?
There's going to be bits of it because you need to shut the video off to take pictures, but. So when I was taking pictures of the open intox and I needed to shut the recording part off in order to take photographs.
It didn't seem more, practical to take video and then photo.
I can't attach video to my reports, I attach photographs.
That's what I'm saying. You started the video. You said that you started the video and then instant search the video. And then you said you shut the body cam off to take pictures.
That's correct.
So when you shut the body cam off, were you done to take a video?
And what I need to see inside the vehicle, yes, there's most likely going to be video of the open intox, so I need to take specific pictures to show the empty cans, the full cans. In fact, they were still cold, the sweat on them. I need to take individual photographs and just report it, because I can't attach recordings to my reports.
Right. So what I'm trying to establish here is that you started taking video, then you stopped it, and then you took pictures, and then you started video again.
That is correct.
That's what I'm asking. I'm asking you would have been more practical to either take the photos first or take the video first, so that you wouldn't have to interrupt that video.
How am I supposed to know there was open intox in the vehicle before I went in there to take photographs?
Well, you would have proceeded with the video, that would have shown.
I was initially recording when I went inside the vehicle. When I observed the open intox, I needed to take photographs. So I needed to stop my video to take photographs.
Stopping the video isn't, because you wanted to stage something.
That is correct, sir. You can see in our.
This is going to be a no contest plea.
Yes, Your Honor.
Waiting for a copy of the form. What charge?
Receiving and concealing 200 to 1,000, Your Honor.
And then upon that plea, count one would be dismissed.
Yes, Your Honor.
Correct, Your Honor.
And was there any other parts of this agreement?
No, Your Honor.
All right. I'll sign off on the form once I see it. May I have him sworn?
That's right. You solemnly swear to affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth, so we got.
Yes, ma'am.
Lower your hand and state your name again.
Deontay Smith. All right. Sir, it is this court's understanding that you are going to plead no contest to the charge of receipt and concealment of stolen property 200 to 1,000. Correct? Yes. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. Do you understand that? Yes. All right. Do you understand what a no contest plea is? Yes. All right. 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that? Correct. The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? Correct. Basis for the no contest plea?
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
No contest.
And you understand that by pleading no contest, you will not have a trial of any kind?
Correct.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights in that form.
Correct.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything
No.
other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will?
Yes, sir.
All right, the court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 25286. Any objections to the court having reviewed that report?
None from the defense, Your Honor.
No, sir.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you, if between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any sentence evaluation or recommendation. The court would not be bound by that, and you would not be entitled to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None known to the defense, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be November 12th, 2025, 9 a.m. That's before me. Bond will continue.
All right, thank you.
Thank you, Your Honor.
Thank you. Court does call the case People versus Emmanuel Sneed.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Sneed, who's previously resumed. Mr. Sneed, will you state your name for the record?
Emmanuel Sneed.
All right. I have before me that he's going to plead no contest to the charge of operating while intoxicated, second offense.
That is correct.
That's correct. Excuse the dismissal of the third. That's absolutely right, Your Honor.
All right. That's the court's full understanding of the agreement. All right. Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. State your name again for the record.
Emmanuel Sneed.
All right. Mr. Sneed, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is you're pleading no contest to that charge. That is a misdemeanor, punishable by up to 1 year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, sir.
Court could also order community service and any rehabilitative services the court deems necessary. Could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
All right. And do you understand what a no contest plea is?
Yes, sir.
All right. Did I ask him to plead? And so, sir, to that charge, how do you plead?
No contest.
All right. I do have to advise you that a no contest plea does mean that you're not further desirous or wanting to contest this case, and that advise you that the court will treat you the same as though you had pled guilty. You understand all of that, sir?
Yes, sir.
For purposes of the record, basis for the no contest plea.
Lack of recall.
All right. And you still wish to plead no contest, is that correct, sir?
Yes, sir.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Or had it signed on your behalf?
Yes, Judge, I did
Yes.
provide a copy to him and he gave permission for me to sign that on his behalf.
All right.
Reviewed that with
Is
him.
that correct, sir?
Yes, sir.
Do you have any questions regarding any of those rights on that form?
No, sir.
You understand that you're waiving or giving up all those rights that are on that form?
Yes, sir.
Has anybody promised you anything other than what's been stated there here today on the record to get you to plead?
No, sir.
You also understand, so you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
All right. Has anybody threatened you or coerced you in any way to get you to plead?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
Court has been provided and has reviewed Pittsfield Township Department of Safety report for their case number 204071. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
All right, sir. Well, based upon a review of that report, court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of the offense. The only thing I do need, because of what's contained in there, counsel, you stipulate to the prior.
Yes, Judge.
Very good. All right, based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between now and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that you would not be entitled to any sentence evaluation or recommendation to the court, and the court would not be bound by that. And you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Judge.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
November 12th at 9 a.m.
November 12th, 2025, 9 a.m. before me.
Thank you. Your Honor, a couple of things regarding that. Mr. Sneed resides in Florida. I obviously have discussed
On
with.
purpose?
I think so. Sounds like he likes it.
He likes it there? Okay, all right, whatever.
So I did inform him he's going to need to contact probation. I've also discussed with him the mandatory 5 days jail. I wanted to ask the court would he be allowed to appear via Zoom for the sentencing? And then I've talked with Ms. Perny and Ms. Perny specifically about allowing potentially for him to report at a later date to serve that time during the course of probation. But I just wanted to see what the court.
You talked to them about that? What'd they say?
They didn't give me a solid answer.
They didn't? Why? Because there's no telling what I'll do.
I mean,
Is that what they?
that might have been
Is
like
that
the
what you're
gist.
really saying?
Yeah, a little bit. But I just want to make sure Mr. Sneed's complying with whatever you were asking.
He needs to comply with that. We'll work that out with sentencing. Probably best to address that, have it addressed to Miss Parent or Miss Teresa Plar.
Okay. Is he allowed to appear via Zoom for the sentencing? Well, once they make that request.
Why is everybody pushing? I need the request made. I will understand it.
Okay.
My staff will, we will.
Okay, understood.
All right.
Thank you.
Thank you. Bond continue. Thank you, sir.
Thank you, John.
Court does call the case. People versus Michael Stone.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Stone. Mr. Stone, can you unmute and state your name for the record?
Michael Stone.
Your Honor, we're asking for an adjournment. We had we got new contact information. Looks like today for Mr. Stone, there is a misdemeanor offer extended. I just need some time to talk that through with Mr. Stone.
November 13th, 2025, 9 a.m. bond continued.
Okay.
Thank you, sir.
Thank you.
Court calls case of the people versus Justin Straight.
Trevor may vote for the people. First time.
Whose case is this? No, I'll wait. Oh. Look. You don't worry about it.
Okay.
It's all Cannon's fault. Okay? You're good. Even though I had to wait. I know it had to be Miss Cannon delaying. Go ahead.
I am Renika Glenn requesting, I would like to request permission pursuant to court rule.
Didn't they? She didn't talk to you about anything. You're good. Don't worry about it, Mr. Starr. She didn't talk to you about anything, did she?
What did I do? It was quick. It was quick.
No, geez, oh, Pete. This gets so, well, no, she didn't talk. You know what? You know what? You need.
Says it could be more than once.
What?
If you read that little court rule,
Oh, it could be more than once, but it's really up to the judge.
It is.
That I only need it once per session. And she was just up here. Do not try to cover for what you did trying to send her up here to get her head chopped off. Jeez, Cannon, protect your intern at all costs. You're good. You've already asked permission. I am I am so happy I was able to grant it. So you can just go ahead, counsel.
Thank you. I am asking for an adjournment on behalf of my client, Mr. Straight.
Hearing no objection. Probable cause conference will be adjourned. Mr. Straight is like, I don't know what was going on. To November 13th, 2025.
Actually, Judge, our client,
So that's not good enough? No, go ahead.
no, our client has something else to take care of on the 13th as well as the 20th. So we can please have a date
Please.
after the 20th. Please.
You need a date after the 20th.
Yes.
Set it. Then I will set it. That was very nice how you asked, counsel. Unlike your supervisor. I will adjourn this out to November 25th, 2025. That's a Tuesday. That will be it. No, that will be at 9, right? That is at 9 a.m.
Your Honor, can I be reviewed on bond?
You may.
Will you clarify for my benefit whether or not the defendant is currently testing or required to test?
I think that he is testing. His last test that I have here was October 20th.
Yes.
You did today too?
I did Monday, and I got a call Sunday from my number.
Okay,
I
so
went
the
down
last,
Monday.
gotcha. So he's testing, because the last test I have a report of is the 20th.
I have a
And
report.
no, you're good. You're good.
Thank you.
You're good. That's, people start talking, that's how they get in trouble. And then their attorneys got to argue, try to keep them out of jail, and then it's a big old mess. You're good.
Okay.
You okay? You relaxing?
I'm good.
Because you stressed me out and you did her too. All right? You're welcome. His bond will continue with its condition. Thank you, sir.
Thank you.
Oh, now she's coming up. Yes, you may approach. Geez, oh no, wow. Come on. No, she just launched. I didn't know what to do. Lee was about to draw down on her. It was a mess. I told you, Cannon, protect your intern at all costs. Court calls the case, people versus Leo Stringa.
Trevor may vote.
Edward Dadish on behalf of Mr. Stringa. Mr. Stringa, can you please say your name for the record?
Yeah, Leo Stringer. Good morning or afternoon at this point, sorry.
Good afternoon, sir. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
He's going to plead to an added count 3 of use of fentanyl, first offense, a 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Judge.
That's correct, Your Honor. Thank you.
Mr. Stringer, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record.
Leo Stringer.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of fentanyl. That is a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. And understanding that, you still wish to plead guilty?
Yeah. Yes.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
All right. You signed an advice of rights form or had one signed on your behalf?
Yes.
That's the 2-page. Okay.
You have any questions regarding any of the rights that were explained to you?
No, my attorney did a good job of going over those with me.
And you understand that you're waiving those rights, sir?
Yes, Your Honor.
All right. You understand also you're giving up your right to appeal of right?
Yes.
Anybody, are you on probation or parole?
I'm not on either, but I think it's pending with
He's getting
with you, I
sentenced
believe, on
another
another case, Your Honor.
All right, but at the time of these offenses, you were not on probation or parole. Is that correct?
That is correct.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Unfortunately, yes.
All right. On July 29, 2025, at the location of 3135 Washington Avenue in Pittsfield Township, Washington County, State of Michigan, did you have fentanyl in your possession?
Yes.
All right. Did you know you had it?
I didn't know it was fentanyl, but I knew it was an opiate. I don't know, should I not say that?
All right, no, that's fair enough. All right. And had you used it?
No, I didn't actually get the. No,
You
I
didn't
didn't.
get a chance, but you did possess it at that time.
Yes.
All right. So I could take the higher charge anyway. All right, sir. I do have to advise you, if you commit misconduct between the time of my acceptance of your plea and the time of your sentencing, misconduct as defined under the Michigan court rules, you would not be entitled to any sentence evaluation or recommendation. The court would not be bound by that, and you could not withdraw your plea. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements that have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
You have.
Defense is so satisfied. Thank you.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be November 12th, 2025, 9 a.m. That's before me.
Okay, Your Honor, can I ask, just because of my medical situation, can we do that via Zoom as well?
You talk to your attorney and they will submit the proper paperwork and then we'll make a determination, okay?
I'll
Okay,
talk to you
thank
right
you,
after court, Mr. Stringer.
Thank you. Bond will continue.
Okay. All right, have a good day.
Thank you, Your Honor.
Thank you.
Thank you, counsel.
Thank you.
She didn't do anything. No, okay. No, I'm sorry. No, you guys were
Very
talking.
good.
I'm sorry.
She had an
I
hour
didn't mean-
conversation with me on the phone over the past week.
All right. Thank you, sir.
And about 100
Court
texts.
calls the
Have a
case
good day.
People versus Carisha Turner.
Chairman Dadush, on behalf of Ms. Stringer, who should be appearing by Zoom.
Oh, there. See the name.
Hello.
Hello, Ms. Turner. I'll need a camera, please.
Okay. Hello.
Oh, there she is. Hello. All right, what are we doing?
Your Honor, we are going to be setting this matter for preliminary exam, and to our knowledge, all discovery is complete.
All right, would the people have their witnesses available on the 4th?
Yes, Judge.
Preliminary examination in person will be set November 4th, 2025, 9 a.m. That is before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Michael Umber.
Good afternoon, Your Honor. Victoria Burton here. She was just here on behalf of the people.
Well, look who showed up.
Ready, Judge. Torshell Feature, Assistant Public Defender on behalf of Mr. Umber. Mr. Umber, please state your name for the record.
Michael Umber. Thank you, sir.
Thank you, Judge. I have been in contact with the chief about this case, and we are trying to get it resolved.
Wait, you didn't know her name?
I don't know her title. Is it deputy chief or just chief assistant? You know, it's different.
One is an official title, the other is actually what happened. So,
but I have spoken to Ms. Burton here about this, Judge. I do need on this file. Mr. Umber has provided me with some documents today. I need to pretty them up and add them to with mitigation information and hopefully get a resolution.
okay, without objection, I'll adjourn this. Will the 13th be enough time for you, Mr. Priester, because you can't find a pen?
It should be, Judge.
Okay. Probable cause conference, November 13th, 2025, 9 a.m. Bond will continue.
Thank you very much, Judge.
Thank you. We're good. Thank you.
All good.
Appreciate it.
No problem.
Let me get back
We'll be
down.
in touch next week. All right. Yes, sir. All right, hang in there.
He's in custody.
Thank you.
I tried to send you the, he's the only one that got
Correct.
So, all right. Folks, on the case of Aldier, whose case was that?
That's fine, Judge.
We cannot get an Arabic interpreter. I was gonna put it out a week because the jail that's the only person I've got up here. Is there any objection to that, or?
Can we approach on the matter?
You can.
Mr. Schmidt, do you have an ability to update me on where we are, or should I just ask Ms. Haler?
Based on my discussion with her yesterday, I believe what we're going to do today is pleading to the ticket for $150 inclusive of costs.
Is that correct? Are you accepting that offer, Ms. Haler?
Yes.
All right. So how do you wish to plead as to this ticket?
Can I do no contest?
You sure can.
Yes, no contest.
Court will enter no contest plea against you. I will assess $150 for the forfeiture pursuant to the agreement. I think that sounds appropriate. When will you be able to pay that?
I will be able to have it by the end of the month. I'm hoping I
Excellent.
should have it by, I should have it by the end of, or like 10 days at the most.
Excellent. I'm going to say 30 days to pay, so it gives you a little bit more time. But just know that if you don't pay, the court will enter a civil judgment and a warrant will be issued. You could sit up to 6 months. So just make sure that you get that paid within that time frame, okay?
I will.
All right, thank you.
Thank you.
We are adjourned.
Dash cam, as well as my own body cam that gets turned on immediately after I take photos. I don't carry open intox in my patrol car to place in other people's vehicles.
No, I would say you place there, I'm just saying.
They're accusing me of
Perhaps stage scene.
No, sir. Everything in the vehicle remained the exact same spot. Everything that was in there before I got there was the same after. There was nothing that.
I mean, that's testimony now.
That's the case, yes, sir. Okay.
You now here is spoken. You're telling the truth, or keeping that touch.
Yes, sir, as can be seen on video.
Okay. Now let's fast forward to your police work. Did you or Officer Matheson comply with this police report, or did you?
I wrote the police report.
You wrote the police.
That's right.
Okay. You tell the truth, the whole truth.
Yes.
Here on page 4 of 7. It says on one line where it says relationship, it says Carrie Stokes was the driver of the vehicle. Jason Darnell Porter was the passenger of the vehicle that stated that Carrie Stokes was the driver of the vehicle.
That's correct.
Why was your video on the interview of the support?
Mr. Porter was interviewed, as you can see on the top, by my partner.
What was the video?
There's gotta be body cam footage of it.
We can turn the overall body cam footage, whether someone's on or off, I don't know. Sometimes they're on or off during lead information, whatever it is, sometimes. So you turn them off, turn them on. Sometimes they don't go on. You know, there's some video with regard to Matheson. There is no video with respect to the DPO reporter.
Real quick, I just wanted to touch on it's your alleged interaction with me. You said that you said on record, and you also said police report that I refuse the PDT.
That's correct.
You still testify.
You did refuse the PDT, that's correct.
Okay. Well, right here in the police report, under where it says PDT, it said not taken due to circumstances of him needing medical treatment for his mostly unresponsive state. Officers believe this to be consistent with being highly intoxicated, as well as to those beer bottles in the vehicle. So,
If he's gonna be excuse me, objection, if he's gonna read in portions of the police report, you also see it.
yeah.
Go ahead. You can approach. You can approach.
You have a comment?
Yeah.
Fine.
Thank you.
Correct, and the response to that, it's the same as inevitable discovery. Your inability to even speak with us, is the same as a refusal. You were never charged with a refusal, you were never written a citation for it, you were never attempted to be charged with it, but you not being able to speak or talk to us is a refusal. You are not able to consider this. If you are unable to talk to us and say, yes, I'm willing to take this because of your high level of intoxication, that's the same as I put in there that, you know, we didn't charge you with refusal, but it was inevitably refused because if you weren't able to take it. Because you couldn't speak.
I'm saying, it says who?
Says him. He's testifying. That's what he's explaining to you.
Like, is there something in the protocol? Is there some type of rule that says that?
If you are unable to complete a certain task based on your level of intoxication or just, if you had someone with, for instance, if you had an individual who was paralyzed, you can't ask them to do the walking tour. That's not, they can't do that. That's not a legitimate request. So if I'm requesting you to take a PPT and you can't even see, that's a refusal. You can't do
it. That would be an inability.
And just to clarify, you were never charged with it. We never tried to charge you with refusal.
No, I never said.
But you not speaking to us should be perceived as a refusal.
I was speaking, you just couldn't get it.
Okay, it's Q&A. You're going to have a chance to make all the argument you want to when you testify, if you testify. But this is just Q&A. He's answered the question.
Okay, I want to direct your attention to page 507, the very top paragraph. It says, here on Valley Ambulance employee, Cody on place. And more, he, previously testified, had advised that there was a male later identified as Stokes, was originally uncooperative and refused to get out of the driver's seat of the vehicle. Here, sure, Valley Ambulance, no, I'm sorry, okay. PBA at the ambulance. Right, the ambulance later advised that they were able to get the male out of the driver's seat. And took him in the ambulance due to his mostly unresponsive behavior. He says high levels of intoxication. It seems, I want to ask you, I'm not asking you, but it seems as though you're alleging your report that Mr. Colby and Ms. Laura observed me in the driver's seat of the vehicle. Is that correct?
I do not have my Cat D card with me, but the original call that we got, the phone notes that we have, I do believe said that exact thing, that there was a male in the driver's seat who was uncooperative, who was not getting out of the vehicle, and then they were able to get him out.
Who said informed you of that?
Yeah, our dispatch notes, I believe, reflect that.
Your dispatch.
That is correct.
So why would you send a report your dispatch or you names?
I don't have it under an interview. I'm not putting that word to someone else's mouth. I'm simply saying the dispatch notes that we got stated that. But that's my recollection. That's what our dispatch notes said.
So why would you name two people specific?
Because that's originally, we got called by the ambulance is what I was originally told. I cannot verify that.
So you can't verify that anyone, let alone Kobe or observed in the drivers.
I actually, unfortunately, they were not seeing it. This was later found out that a police officer did observe you in the driver's seat. A Huron Township police officer observed you in the driver's seat.
Well, what you look as far as to specifically name these people? Why wouldn't you go as far as to name that specific officer?
It was later discovered after the report was already turned in and submitted.
So there is such thing as an amendment.
I cannot go back and edit my reports to my groups.
You're say that him saying that another officer said that that's hearsay because he had no evidence of any officer saying it. Yes, no evidence, that's hearsay.
Okay, well, hearsay is only important if there's an objection, and there's no objection, but your record, you've made a note for the record. Okay. Mr. Greco?
And he's asking the question.
Right.
Rules in court is that if you ask a question, you might get an answer that you don't like. So you're supposed to be careful at the